Today is Tuesday, the alleged 30th day of the month of December, year of our Lord, 2025. And we are gathered here today as we have been almost every Tuesday for the last like 7 years, guys.
Wow.
From September 2018. I think that was the September 8th, 2018 was the first post on the Friends-in-Law group on Facebook. And sometime September 19th was the launch of lawfulliving.com's first iteration. Some of you guys have been with us since that time. And some of you may have just found out about us yesterday.
Word.
Or even this morning, or even right now. But regardless of when you got here, we are grateful for your presence. And we hope that it has been and it will be impactful positively in your life. Are you Hamilton? How long ago were you kicked out? My admin kicks people out of groups when they're misbehaving. Sometimes I don't even know. Someone said I've missed years. You haven't missed anything, especially if you are taking advantage of our classes that we have available, many of which were recorded years ago, but we are using laws that have been around for the written law version for centuries, and of course, stemming from natural law, which is immutable. So you've not missed anything when we're talking about principles here, not loopholes or gimmicks, um, or processes that once they get out, they quote unquote change it on us. That's not what we talk about here.
Oh, wow. I've heard that one before. This is a new system. We're going to use it until they change it and come up with something different.
Ridiculous. Why even bother with stuff like that?
It didn't make sense to me. So, hey.
The law from the beginning is perfect.
Like I said, sis, if you want me to, I got a little little
Yeah, go ahead. Now that we've done our
treat.
welcome, are you gonna share your screen?
Yep, and let me put this little study treat in the chat,
Let me
and
get my glasses.
now I'll share screen. I trust this is good enough for Newbie Tuesday as well as our advanced um, members also, right? Um, because I
Um,
think it's foundational. Um, And so now what I'll do is I'll share my screen. You all just let me know if you all can see my screen. Are we all seeing my screen?
Yes. Origin of eminent domain.
Yep. The
yeah,
name.
you can see it.
Okay, good. So the name of the document, you guys click on it in the chat for those of you that are here with us on Zoom. Um,
Origin of eminent domain. Okay.
so we're analyzing comprehending eminent domain. And what it starts out with is Um, shout out to Trade Brigade because I made sure that this was at the very top of the document, quoting Upton Sinclair from his book I, Candidate for Governor. and how I got licked. Quote, it is difficult to get a man to understand something when his salary depends upon his not understanding it. End quote.
You
And
should
that's
just pause right there because every time we go over this quote, I think it still goes over people's heads a little bit. Sometimes we jump right to fraud
mhm,
or corruption. And oftentimes, this is the major barrier. What do you
absolutely.
guys think?
Oh, absolutely. And in a lot of ways, I can understand because if it were me and I just learned that the things that I've been doing at work for 10, 15 years has actually been against the law, I probably wouldn't be trying to hear it.
Yo,
I don't think people appreciate that position. A lot of people like to think themselves holier than thou and think that, oh, if it was me, I would just automatically do the right thing because I always do the right thing. I
gotta make
always
sure.
make the right choices, right? I
Word.
never I never make choices or say things based on my purse, my pocket, and how it's going to be impacted.
That's better. Okay, I'll just leave it like that. My bad, sis. Go ahead. I was checking on your live feed to see if I should put it in print layout or just leave it off a print layout. And I
I
think
think that's
off
good
is
there.
better. Yeah, off is better. It fits your whole camera so that they could see. Excellent. But go ahead, sis. Finish what you were saying. Are you?
I just wanted to point that out and make sure I highlight it for people. When we're talking to attorneys, and we're talking to judges, and we're talking to administrative agents, we're talking to clerks. Sometimes
And
we do
remember,
jump
guys, you want to make a
straight to
copy of that. You're gonna
we do go straight to fraud, don't we? We go to straight to fraud or corruption.
Word.
But what about I gotta feed my family too?
What about cognitive dissonance? Because that cognitive dissonance, it hurts. It feels weird.
Word.
It's
Word.
important to put the agents in that uncomfortable position by saying, "Aw, I know why you can't hear what I'm saying clearly. Sometimes I'm saying bullshit, which we have to embrace, because sometimes we are, but also sometimes it's difficult to get a man or woman to comprehend something when as soon as they do, they have to sit with themselves and realize that they may have been harming people that they thought they were helping for years, if not decades.
Facts.
Do y'all think that would be an easy thing for someone who sees themselves as a law enforcement agent, officer, court officer, or agent, oath taker? You think that might be a little difficult for them? Let's talk about it.
Wow,
That would
that
be
Yeah.
considered
means
revolution.
the and
What was
almost
that about revolution? I'm sorry, I didn't hear that.
I said that would be considered revolution.
What if we put ourselves in the shoes of the agents that we're trying to meekly instruct?
No, if they were to just take it upon themselves to do the right thing.
But they do think they're doing the right thing. Isn't that's what we're talking about? Most agents don't go to work saying telling themselves, "Who can I disparage today?"
word.
Most people wouldn't say that even about their own job. Anybody can relate to what I'm talking about?
Yeah.
Word.
It
Yeah.
reminds me a lot of when you realize you've done something to your child that you need to apologize for. That uncomfortable feeling of like, but I'm supposed to be in charge and I'm supposed to know what I'm doing, but
Gotta
you made
stand
a
your
mistake and
ground.
now you have to apologize, right? That feeling.
Yeah, that's what the agents might be feeling.
Word.
Have you guys ever seen that video of that doctor that is like doing I don't know, it's like a talk or something. He's up in front of an audience and he apologizes because of the many years that he had recommended for them to give their kids shots, and he starts crying because he's like, I have to do this. I have to say that I'm sorry because I realize now I was wrong.
We're giving the agents the same opportunity, are we not?
Yeah. Yeah, it's pretty awesome.
And it's very interesting too, because when your inquiry, Malika, um, immediately brought Dennis Bonino to mind. Um, the being, I think that's kind to say, from near the New Jersey State Republic that um, started street cop training, and it seems as if that is a doubling down of purposefully not understanding something because they're forcing themselves to have a better salary and be promoted through the, as the governor of New Jersey said, unconstitutional police training through Dennis Bonino's street cop training.
Yeah.
So that seems to be a doubling down of their difficulty in understanding what their actual duties are.
And that street cop training, which I want us to talk about, was very important because it's being sold under the guise that they are in fact following the law, guys.
Correct. And one of the things you'll hear these
They
policy
market it, they
enforcers,
market it as Fourth Amendment compliant training.
correct. And it's sad because they'll use Pennsylvania versus Mims out of context, where they'll use that to say they can order you during a traffic stop out of your land conveyance. However, that is only contingent upon that they feel that they're in danger. And so it's no different than you stepping outside the door of your home to speak with them within the curtilage of your home, right? Your porch, your driveway, the steps, i.e., whatever that may be for you. So Pennsylvania v. Mims is being um, quoted by these people on the side of the road as a means to neutralize anyone fending for themselves on the side of the road that's competent. And this is why we're saying just take the fucking ticket
Yep.
because these people think them just parroting Pennsylvania v. Mims, absent the comprehension of that case decision and the contingencies that must be prerequisite, right? The prerequisite conditions for Pennsylvania v. Mims to be asserted. They are taking that completely out of context to remove people from there. And what it does what they call um, interdiction, right? A de-rug interdiction, right?
Where they're adding
Um,
things that are not there.
Correct. And prolonging the stop. They're not supposed to be prolonging the stop just so that they can do an investigation to justify the investigation. Okay. So it has sparked in me to confer with the jurisprudence gym because everybody within the amici curiae here at Lawful Living, we all have these moments of clarity and inspiration, and it leads us to um, preparing what you see before you right now, right? And I know all of us in Amicus, in some way, shape, or form, have these like, for lack of better terms, book reports that we kind of just keep to ourselves and shelve or what we share amongst the Amicus. And however, it eventually gets to you all too once we've allowed ourselves to filter it to something comprehensive that can be absolutely studied and used so that you guys can have more of a solid direction in terms of having your feet on the ground and not being afraid to put the gloves on when you go, into, punching the tears out of these attorneys, proverbially speaking. All right. And I'm not promoting violence. I'm just,
I'm
being
promoting violence.
colorful. Okay.
I'm promoting violence.
Okay.
Sometimes violence is the answer.
Am I playing good cop good enough, guys?
You're
Anyway.
doing great.
Punch him with paperwork.
All right. So let's get started. So in the jurisprudence gym, of course, because as Trading Brigade say, you're really speaking with the Akashic records. It's your own mind that you're having a conversation with. However, uh, it's very true when it comes to jurisprudence gym, so to speak. It's just we're speaking with all of us when it comes to that. However, the inquiry was simple. It is two tabs, of course, because the first tab, of course, is pertaining to explanation of eminent domain, and then the other one is analyzing just compensation. Because as I do these analyses, of course, there are more things that pop up in my spirit, and I don't stop until I feel that exhaustion of the inspiration. Because to me, that's the
That's what's
Akashic.
required.
Yeah,
That's
that's
what's
me.
required. You got to
Uh,
get to the end. Okay, I think I've completed this line of thought.
Yeah, and this might be one of the shortest ones because there's others where I have like 7 tabs in. It's like, you know what I mean? It's like,
Let's get it. Let's get it, bro.
all right, inquiry. What is the origin of eminent domain? What does eminent domain denote? What is its purpose, intent, and use? How was it used from its inception, and how is it used today? That's my initial inquiry because that's all the questions I had that popped in my mind. All right. So below is a structured source, grounded explanation of eminent domain, its origin, meaning, purpose, intent, and use, presented historically, and then contrasted with modern application. Will separate doctrine from later expansion
Uh-oh.
and will flag where modern practice departs from original scope. All right.
Dang.
Shout out to the squad, right? Jurisprudence Gym, right? All right. First one, Roman law imperium. The earliest conceptual root lies in Roman law under imperium, the sovereign authority of the state. Property could be taken only for public necessity with compensation viewed as a moral duty, not yet a formal legal right. All right. B, natural law philosophers.
I'm against that shit from jump. Like, how
Yo,
you gonna just take my shit and then toss some coin at me and be like, well, it's the least I can do. Let me just throw you some. Like, that doesn't make me whole.
it does
That's
not.
what?
And it
Right.
wasn't it wasn't a value given by the state in terms of thought of what the value should be,
Right. It was just some
right?
coin. I
It,
gave you some coin. Now shut up.
it was the coin based on the one losing the property, what they actually would be losing. That total value was the just compensation they were supposed to receive. And
How
that's
are
why on
you
the
going to
second tab,
reduce my necessity to shelter to some of your fiat? Can somebody explain?
you right where I was. So it's like you're in the spirit of where I was in the beginning. I'm trying to tell you. Natural law philosophers, 16th and 17th century. Hugo Grotius articulated that private property is subordinate to public necessity, but only when necessity is real and compensation is required. Eminent domain was treated as an exception, not a general power. Let's be clear on that, guys. C, in English common law, Magna Carta, 1215, did not expressly authorize eminent domain. Instead, it restricted arbitrary takings. Are we clear on that? That's huge. That one was huge for me. Not not the Magna Carta being huge. I'm talking about restricting arbitrary takings, which is the protocol of most of these people today, i.e., your mortgage servicers, their attorneys, and whatever bank is popping up saying that they, are on the side with the servicer. And well, they're not saying it. We're saying the attorneys are saying this shit, right? All right. So, in continuing, give me one moment so y'all can be able to hear me clearly. For man just starts doing this thing. All right. So, English takings historically occurred through parliamentary acts for specific public works, roads, canals, never by general executive discretion. Keyword is never. Now, according to Blackstone, 18th century, William Blackstone described takings as, quote, an act of the legislature for public use and with full indemnification. Key point, no inherent executive power, only legislative authorization for a defined public use. A lot of the takings are happening via the executive branches of government. Okay. What eminent domain denotes? Definition by construction, a literal meaning from Latin dominium eminens, right? Dominium eminens, which is supreme ownership, quote unquote. It denotes a limited sovereign power to appropriate private property for public use, conditioned on just compensation. So nothing can be taken without you being compensated. That's what I got from that. Period. It's not maybe we'll compensate you. No, the taking must come with just compensation. That's the condition. We clear? Are y'all liking this so far? Put a one in the chat if you like it.
Yes.
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 All right, cool. What does it not denote, right? That's interesting. Let me back that up so that doesn't look all weird to you guys. What does it not denote? All right. By negative implication, expressio unius est exclusio alterius. It does not denote general ownership of all property. Malika, where you at? I figured you were gonna laugh on that
I
one.
am right here.
It does not denote general ownership of all property. It does not denote that. It does
So
not. Go ahead, bro.
no, I was waiting for this part,
I know you was, bro.
Since since OCGA Title 44 talks about property, right? And there's a
Mm-hmm.
definition that I just shared in the chat, Title 44 1-1, property defined, and it says that which is subject to being owned or enjoyed. Property.
That. Go ahead.
Yeah, I'm just repeating that which is subject to being owned or enjoyed. You're
Indeed,
talking
bro.
about eminent domain of someone's time as property. But I yield.
Ooh, hey, I got there too.
So that the
Definitely
attorneys
went
don't
there.
like that. The attorneys don't like that type of talk. Property, time is property. They were like, time is not in the
That
Fifth
that that
Amendment.
that which
Time
is
is not in the Fifth. How could time not be in there?
that which is subject to being owned or enjoyed.
I mean, can I own my time? Can I enjoy my time? I mean, like, what are we
It's your
saying?
property,
It's
isn't it?
the
Word,
property. They don't want your time to be included in the thought process of property. And I'm like, N word, how? How could it not?
word. Right. Y'all appreciate y'all putting the ones in the chat. I'm glad y'all are attentive. Gratitude, bro, for that addition. It does not denote a police power.
What? What? It doesn't denote. So what are the policy officers doing at the crib?
Uh-oh.
Exactamundo.
What are they doing
No,
there?
no, you see, I'm looking at this police power in a broader context, right?
Mm-hmm.
From that section 10 that talks about the state exercising their police powers, which is more so done through the executive branch.
Yes.
Exactly. And it
That's
just
the
said,
problem.
hold on.
Yeah,
And
it's
it
done.
said, hold on. You're right. Hold on. Where was it? Hold on. Where was it? Oh, right there,
The
bro.
executive,
Here we go. Right there, bro.
yes, there you
Yeah,
go.
so it's not limited to the cop standing at your door or even at your window, but more so to
We're
making laws for
encroaching our
the welfare
policy.
of a public good and implementing policies for the preservation of the public good, health, welfare, as they like to call it.
Correct. That is what they'll call it. That is absolutely correct. All right. I'll continue. So, literal. Oh, that's not proper. My bad. It does not denote. We're here at what it does not denote. What does sovereign, I mean, pardon me, eminent domain, which is supreme ownership, what does it not denote? It does not denote a regulatory power. And it also does not denote a power. Here it is for all you in foreclosure. It does not denote a power to transfer property between private parties for convenience or economic speculation.
So an LLC just can't show up and kick my ass out?
How do your American say fuck no? No.
Yeah, this is fun, man.
I know, right? That's why I was like, hold on, I gotta share this one. This one, I was on it yesterday. I ain't gonna, you know how when your body's warm and buzzing when you on something and you just can't let it go and you lock in? That's where I was at yesterday with this shit, man. I
And
was
for
so
the
locked in. Go ahead, bro.
No, I'm saying for those who truly comprehend, I posted a YouTube link in the chat right there, right? For anyone who might be invited to court. It's just a song. You could check it out sometime later.
Excellent, excellent,
We should play it at the
excellent.
end.
Yes, it's relative to this eminent domain and property.
Word. As above, so below link for y'all on TikTok. Make sure y'all copy the send and then, save that link. All right, so here we go. Purpose and intent, original scope. Okay, so the core purpose of eminent domain, the original purpose was singular and narrow, not plural and broad, singular and narrow, to enable essential public works that could not be achieved through voluntary purchase. All right, to enable, let's hear this again, to enable essential public works that could not be achieved through voluntary purchase. Examples at inception: roads, bridges, fortifications, canals, and later railroads as
Uh-oh.
common
Getting railroaded?
carriers.
Do we get railroaded in a housing court?
Especially if we don't, we're not articulating or framing our articulations favorably.
Yeah, but people don't know what they're actually saying when they say they get railroaded because railroads are included.
Word.
You getting treated like a railroad?
Absolutely. You getting treated like a bridge?
A
Running trains.
canal? Mm.
Hmm? That almost
Hey yo.
sounds that almost sounds
Mm-hmm. That's exactly what I
coital.
meant.
Yeah. Yeah, that almost sounds coital. But anyway, hopefully I can inspire people from saying schmecks on TikTok and just say coitus or coition. Come on, guys, let's expand our vocabulary. All right. It's just words. Let's not be
Go
afraid
ahead.
of it. B, intentional safeguards. The doctrine was intentionally restrained by public use. That word use after public is crime. You'll see why soon. Public use requirement. It was restrained by necessity. It was intentionally restrained by legislative authorization. Legislative authorization. Legislative authorization. It was intentionally restrained by just compensation and intentionally restrained by judicial review.
Uh-oh.
So it sounds like it had to be a thing adjudged.
Remember, it's
You mean you can't
executives and
Franken? Go ahead, bro.
I'm saying it's being done more so by the executive branch, you're saying, and they're the courts of review. The courts for
Hmm.
review. And yeah.
Yeah, not for
Hmm.
the initial taking.
Each
They're doing
element,
a Frankenstein process. This part from over here, that part from over there. It makes it look like I can do whatever I want.
correct. Each element was what, y'all?
Mandatory, mandamus, non-discretionary.
Correct. That sounds very ministerial, right?
Absolutely.
Omission of any omission of any of those mandatory things listed there, 1 through 5, defeated lawful exercise.
Uh-oh.
Sounds like due process.
Absolutely. Eminent domain in the U.S. constitutional framework, Fifth Amendment text takings clause, quote, with an ellipse, nor shall private property be taken for public use without just compensation, period, end quote. Key structural observations. The clause assumes pre-existing ownership. It does not grant the power. It limits it. Public use, quote unquote, is the operative restraint. By Noscitur Associis, taken, quote unquote, is constrained by criminal forfeiture preceding clauses, due process protections, property rights retained by the people.
Oh.
Yep,
Just
yep.
like even that property rights
How
document, the Texas Malika, remember that
yes.
document? Yeah.
Yes. I'm telling y'all, this is what that sent to the county. They were like, we ain't doing no foreclosure. What do you mean? Never
And
heard
that's
of
not
it.
notice what it says. Property rights retained by the people.
Correct.
Absolutely.
The
Not by the
people.
natural persons.
By the
Not,
people.
not by the
How
natural
about for
persons.
by the trustees? Is it by the trustees?
Nope.
That's the monopoly board.
They're not
You
allowed to
mean in the
use it.
mall, like Chris like
Right.
say?
Yes.
Wow.
My protected rights are not adjudicable.
Exactly. They're unlienable. So if you're
Yes.
over here, somebody's claiming a lien to be attaching to something, it can't be this.
Yeah.
You're trying to say
Word.
it's attaching to this.
Show me
And
the provision.
this is my private dominion. So you're saying my private dominion is lienable? Because that's not what makes sense.
Right.
Word. How eminent domain was used at inception, right? Where it started, its beginning, right?
It's
Excuse me.
Pigpen.
For real. 18th through 19th centuries, okay, pardon me, 18th through 19th century practice, so that's the 1700s and 1800s, all right, used sparingly, okay, it was used sparingly, almost always for linear infrastructure,
That's right.
typically, typically required a special legislative act, proof of necessity, and fixed compensation formula. Okay, so that's how it was doing in the 1700s and 1800s. All right, the 18th and 19th centuries. The judicial attitude: courts created eminent domain as, pardon me, courts treated. I misspoke. Forgive me. Courts treated eminent domain as disfavored, strictly construed, and in derogation of common right. That's huge.
And that's what it still is. That's what it still
Correct.
is. The attorneys just decided, you know what? We're not even going to call it eminent domain. We're just going to abuse the eminent domain process and say it's something else.
Correct. 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 Any ambiguity was resolved against the taking authority.
Duh.
There's that ambiguity.
If we're not clear, don't take that shit.
Correct. Told y'all I was in a zone yesterday. I got goosebumps on that beat judicial attitude part yesterday, and it happened to me again today. That's how I know that part right there is like it's something on that right there, y'all. I was like,
Yes.
oh. 6, how eminent domain is used today? Modern expansion, right? Because remember, it was singular and narrow, right? Now there's this modern
I'm gonna
expansion.
blow the whistle on that. I'm gonna say that once your powers are set, you can't just do some shit to expand it. I'm
Correct.
gonna object
True.
to the so-called modern expansion.
You
Oh, so
can't
does the
expand the
jurisprudence.
grant of legislation.
Correct. The jurisprudence gym agrees. Chatija ain't playing. Chatija just doing that. You know how Chatija be. Chatija be like,
It's
oh, you
leading
mean
up.
this
It's
right
leading
here?
up.
Yeah, you know
I
how
know. I know
Chatija
it's
be like,
leading
oh,
up.
this over here? Slap, slap, slap. Come, I mean, oh, this? Hold on, come closer. Are you looking at it? Bow, punch in the nose. It's like, oh, snap, Chatija, chill out. Slow down, Chatija, you're killing them. Okay, so a shift from public use, quote unquote, to public purpose. So it's not actually an actual ratified shift. It's
Obviously not.
right. The modern expansion is a what was the word up there again?
Scapegoat.
A derogation of common rights.
Bastardization.
Yes, all of that.
Word. Shift from public use, quote unquote, to public purpose, quote unquote. 20th century jurisprudence blurred, right? 20th century is the 1900s now.
Blurred, huh?
Blurred use into benefit and necessity into policy
Blurred.
preference.
Is that why they made that guy make that song Blurred Lines? Huh?
Mm-hmm. Mm-hmm. Alan Thicke's son.
Yeah,
Mm-hmm.
we're not doing that for you neither, ho. What?
Mm-hmm.
We're not blurring anything. We're making stuff clear.
Mm-hmm. And that blurring, I think, is the source of the ambiguity.
Yeah, like the attorneys just waved their wand. You're getting sleepy. You're getting sleepy. Y'all hear the cartoon music from the 80s?
Word. Exactly. This is a doctrinal expansion, not a textual one.
Oh, it's like them theories
Word,
and practices.
word.
This is
Tap the
why
live
they're
out, y'all.
illiterate right now.
Got 34 y'all in here. Tap it out. We at 8K, y'all. Tap it out. Contemporary uses. All right. Urban development. Oh, HUD.
Uh,
HUD.
Oh, HUD. How have you no shame?
It's just
Um,
all tied into slum clearance and
and
that
blight.
kind of thing.
And
Look at
blight.
yes, I'll
correct.
allow you to read a sample. Look at even the last one. Transfer to private developers.
Oh,
Having
what? No,
yes,
no, no,
transfer to
no.
private developers, and
No.
that's the most modern in the sense of the private enterprise agreement between the Department of Housing for the
No.
states with the private developers for profit.
Is
Word.
this not literally rob Peter to pay Paul?
Absolutely.
Am I what? Am I missing that?
It's
No.
just making merchandise of men.
We're
Jesus
gonna take your
Christ.
house. We're gonna call it a public purpose. What is our public purpose? Administrative larceny.
For real. Where's McGrill at? Shout out to
I
McGrill
know,
right now.
right? Shout out to Big Real.
Jesus.
Development. I was singing that one earlier. When you read Modern, I'm like, it's called development.
Uh-huh.
It's just an expansion of their commercial boundaries.
Who told you you could do that?
Exactly.
Show
That's
me
the
in writing where it says you could do that. Well,
yeah.
we've been
An
doing
ex
this for slap. I don't want to hear. I don't care how
an
long you've been doing
express
that shit.
grant of law.
That's all I'm
Word.
looking for. The express grant.
Correct. So its contemporary uses again, urban redevelopment, economic development, blight removal, and transfer to private developers. All
Mm.
sounds like theft to me, but won't go there. Maybe we can go there. These uses did not exist at inception and
It relied.
rely
Wow,
on.
wow. Judicial
Go ahead.
interpretation.
No, judicial corruption. It relies because if it didn't exist at inception, who the hell told you could expand it by
Upton
your
Sinclair.
mere
Upton Sinclair.
interpretation?
Back to the top
Right.
of the document. Upton
Let's go
Sinclair.
back. Right. That's the answer to the question. That is judicial corruption.
Because it is difficult to get a man to understand something when his salary depends upon him not understanding it.
Right. And we need to make that they can't comprehend what those liar hole servicers and LLCs are saying when they come in there to make people homeless under public policy that for which it was not created.
Word. Absolutely. All right. So we are here.
Yes.
Below, right here.
Yeah, we're right here.
These uses did not exist at inception and rely on judicial interpretation with air quotes.
Corruption.
Classification.
Judicial misclassification.
Yeah, there you go. It's all types of different shuns, not interpretation. Some bribery. They should say relied on judicial lobbying. Come on.
Hold on. You want to put the
Not constitutional amendment.
Not constitution. So the courts are amending or attempting to amend the Constitution by interpretation or misinterpretation.
But it's like what you even said earlier, Malika. You've been using stuff that been written long ago.
That's right.
It never changed.
It never changed.
Correct.
There was no amendment.
We got two attorneys on TikTok right now coming to tell us that it's America is a democratic republic.
Send them a looking glass.
One just came back today and was like, it's both. It's a republic. How is going to be both? That's like you pregnant or you not pregnant.
Yeah, somebody hasn't read the Constitution where it says that we are guaranteed a Republican form of government.
I don't know if attorneys know this, but I'm going to tell everybody this because it's Newbie Tuesday for those who do not know or have not known before. I hope TikTok can't see. Let me block TikTok eyes from what Queen just said. What was I saying?
How the attorneys drink that bar Kool-Aid?
No, what was I gonna say? The word democracy does not appear in the Constitution ever. Exactly 0 times. The word democracy, does everybody hear what I'm saying? Word. Go and pull up any of the federal constitutions, guys. Any version that you want to call out, even the version after Reconstruction, and find where the word democracy or democratic is in the Constitution. It's not there at all.
At all. My bad, y'all. I'm
0 times. So where does this idea that the attorneys have, where does it come from and where is it supported by? It's literally not in there. You could pull it up right this second. Go off this live right now onto your favorite search engine, pull up a PDF copy, download it onto your computer, and then do a Control F and look for the word democratic. Hey, welcome in, Chana.
Definitely does not exist. These uses did not exist at inception and rely on judicial interpretation with air quotes, but we know it's judicial misapplication, right? Not constitutional amendment. So it's just outright jurisprudence. Jim is like, this is not based on, withstanding. It's not withstanding.
This is not lex scripta. And
correct.
It is actually seeming to be it's smelling like it's repugnant to the Constitution. Is anybody smelling that?
I smell
like it. Smelling repugnant.
Smell. What was that on a Belly at the beginning of Belly? The movie Belly, like smell like a pot of bullshit. Yo, Jesus. Okay, here we go. Structural consequence. Modern practice often dispenses with true necessity,
Wow.
relies on speculative public benefit,
What?
and converts eminent domain into a land assembly tool.
Where did you get the delegation to do that?
From the
Great
corner of
question.
from the corner of Fourth and Nowhere. Let me stop.
This is why I know this is why most people go, oh, we're gonna file in the federal, we're gonna file in federal because it's a federal question. I'm suggesting you may be correct. It is a federal question. And if we frame it correctly, they won't be able to dispense with it out of their necessity to carry on their corruption.
Word. Okay.
A land assembly tool. What?
Instead of it being, you getting it, you can own it or have it ceded to you rightfully, well, constitutionally. Now it seems like this is a way to
Oh my God.
circumvent the constitutionality
Mm.
of having land owned by or ceded to particular spaces, all because people are investing in pooling and servicing situations, right?
Which are tied to the retirement accounts of judges, guys.
Correct. Which means that's unjust enrichment at its finest for me. For me, I'm open for correction if it's not unjust enrichment to others. Summary comparison. Okay, so we have three categories: the aspect, the original doctrine, and the modern practice. So, in terms of source, from the aspect of the source, the original doctrine was natural law and statute. The modern practice is that judicial. Let's
Yeah,
put the quotes again
yeah,
and put
yeah.
misapplication.
Corruption.
Okay,
It has to be corruption because did the judges suddenly get stupid?
gotcha. We'll put that in there for you guys too, right? So those of you that got this link, got this document, hey, look, it's getting edited in real time for you, right? Just to sweeten it up a bit, right? It's a
Scope.
sweet one. All right, scope. Narrow was the original doctrine. Modern practice, it's broad. The aspect of public use, it was actual use by public in the original doctrine. In modern practice, is economic benefit. It just screams bureaucratized slavery when I hear economic benefit,
Mm-hmm. Mm-hmm.
right? Because people don't recognize that now that if you don't have the knowledge of what's going on and you think you're being grown and quote unquote paying your mortgage payments when you get your statements or whatever, or your statements evidence your mortgage payments, you are not giving your payments based on the initial agreement, which was you were to receive actual money, right? Purchase money, right? Purchase money loan, that's what it was. But your promissory note was cashed like a check, like Malika says all the time. And then the proceeds were recycled back to you, which all courts call a failure of consideration or
All of
illusory
them.
consideration.
All
For
of them.
real. Correct. Absolutely correct. All right. Beneficiary was the public in the original doctrine. In modern practice, the beneficiary is often private. Those are
Where
your
do they get the delegation to do that? Look at that.
correct.
Often
Hey,
private.
I didn't even know you were
Uh-huh.
gonna get to this word beneficiary because further up top, I'm thinking about Keith. When I heard Malika mention the trustees, I'm thinking about like Keith when Keith says, if all of us are trustees, and where are the
Where
beneficiaries?
are they?
Correct. And the people, so that means that your servicers with their attorneys and so-called banks, because they're doing the foreclosure, because if you're not quote unquote in good standing and current with your mortgage, then they're like, hey, this hamster on the wheel is dead. We got to find a new hamster
Right.
because it is bureaucratized slavery. So you're funding your own enslavement because they're not called slave owners today in modern practice. In modern practice, it's called investors.
And corporations.
Uh-huh.
And people make it sexy, like, hey, I got a corporation, I got a administration.
Absolutely
It says
correct.
intelligence rule the world and ignorance carries its burden.
Sheesh. Absolutely, bro. From the aspect of judicial scrutiny, the original doctrine was strict. Now, modern practice is deferential.
Oh, is that like what is that thing called? The deference that just got overturned?
Chevron
Chevron.
Chevron?
deference, it's
Yes.
agency enacted or agency regulated. Agency, that's executive agencies, I'm saying, that are doing the taking.
I wonder what year would we consider the transition, the blurring of the original doctrine to the modern practice?
20th
Maybe,
century, it said.
yeah, maybe going up
I
to
know, but what year would we say?
33.
I mean, right?
So you're
I
saying
The
there,
mean,
new Green
so
Deal,
you're saying there is a chance. Are you saying there is a chance?
hey, we
administrative
just talked
larceny.
about you.
So you're saying
Somebody
there
said,
is a
where's
chance.
Big Real? Here you go.
Whoa, what's good, Brody?
Yes, I just talked about the administrative larceny.
For
Yes,
real.
like all of the agencies, guys. Very good. Pick your poison. Yes.
Way to go, y'all. Y'all doing. I can't see the TikTok right now because I'm
It's
making me
okay.
some break fast, but I'm still right here with the iPad on my chest. Let's get it. All right. 8. Core takeaway. Doctrinally precise. All right. Eminent domain originated as a narrowly constrained legislative power of last resort, justified only by real public necessity and limited by strict compensation and use requirements. Its modern form is an expanded judicial construct, not
Oh,
a faithful continuation of its original legal character.
and I'm gonna object on that note alone. Come on.
Objection. This is not a continuation of the original legal character of eminent domain. You
Correct,
see,
correct.
some it,
It's an unauthorized and forbidden expansion of a
correct,
judicial construct.
correct, correct. So now, right, let's get to tab 2 because these things, as you can see, it's not long and it's pretty provocative, right? So here was my next inquiry. Let's get right to it. How is just compensation, quote unquote, etymologically denoted and legislatively defined? What case decisions in any court report or publication show that court's judicial attitude treated eminent domain as disfavored, strictly construed, and in derogation of common right, where any ambiguity was resolved against the taking authority? Break
Yes.
break down public use, quote unquote, versus public purpose, quote unquote, under strict rules of construction. Analyze where modern
Yes.
statutes exceed constitutional
Exceed.
scope.
They can't even see the edge of the pool. They cannot see their limitation. They go, look, it says all property, N-word. We're reading under the Business and Commerce Code.
Word.
It can't just be all property if we're under the commerce. Are you dumb?
You
Or
understand?
or or do we have to go back to the quote in the beginning of this conversation?
You understand? Well, I mean, we can revisit that quote. You want to revisit? Let's go ahead. Let's take
Because it's
a
like
commercial break.
I
Let's go back to the quote. Let's take a commercial break. You
they'll
guys
be
tap
like,
tap
it
the live
says
out.
here all property. We are under the business use code. We are you how could it can't just be all property just because anything is called property. It has
Correct.
to be we're in the commerce clause.
Correct. Correct.
We're in do you not
Correct.
see it says right here because that's what gave up the whole goose for me when I was researching from when we lived in Texas 10 years ago. I went to read the transportation code, and to get there, you had to go into the commerce clause. I'm like, what is happening? Is this suggesting that if the use of the motor vehicle, if you want to even call it that, is not it for a commercial
Word.
purpose, then you cannot in fact be driving or exceeding the speed limit or double parked or illegally parked or stopping, standing, soliciting. You can't be doing any of that.
Correct. Correct.
And
Correct.
we have people both
Oops.
on both sides, on the so-called law enforcement side and on the victims of stupid law enforcement side, that it's lost on them that they had to go into the business and commerce code to get to the section about any kind of traffic violation.
Word.
Why do they even have cars that go 200 miles an hour, but they want to limit everybody to 70, 75?
Well, why do we just assume it's everybody just because there's a bunch of people complying?
Some
Well,
of you motherfuckers can't drive.
And some of us
I
just
second that
don't.
motion. They can't drive, so that's why they gotta have a
And
little
some
more
of us just don't.
guidance.
Hey, who been over 180 in this motherfucker? Let me know.
I've done it before. I've
I have.
definitely gone
Oh,
pretty
look,
fast.
McReal, only when we going through the toll.
Just, hey, I got pictures of my ass going through the toll, not paying.
Wow.
In
Ricky
in
Bobby
color. In color.
in living color.
Me
Who wants
too,
to
bro.
who wants to read that
Hey, I'm gonna post them for y'all.
Y'all are hilarious, yo. Y'all are
Man,
so
where did he come
hilarious.
from? Did he get cloned? You don't even sound the same.
Oh no, that's
Hey,
not real.
That's
that's
him.
that's
That's
because I'm in the
McReal.
that's because
I
I'm in
think
the
he got
mountains.
cloned. I
Oh,
think
you
he's
in the
been
mountain
cloned.
now, bro? You close? Come through, come through.
Hey, no say. I'm sure I'm gonna pop up.
Word.
I'm
He's
hey,
flying like an eagle. That's all. He's just
I'm
flying like an eagle.
I'm gonna pop up.
Yes. You know the
Yeah,
longitude and
I thought you
latitude.
said it was cold up there.
It's not, look, it's not even snowing. Let me show y'all. It's
I
crazy.
know.
Look,
That's good. You got high ground now.
y'all see that?
Hey, and the ground is soft. I'm like,
And the
woo.
ground is, look, no, it froze a couple days ago.
Yeah, it's soft. That means it's soft. It's
It
wet.
might. Look,
It's
it's a
wet.
very strange time. It is. We went over to Idaho for a couple hours yesterday, and they had like a quarter inch of snow, like literally, like I got
Yeesh.
pictures I'm gonna show y'all, like just
The
a
shit
little,
melted already, huh?
probably.
Did you get some potatoes?
I did.
Yo,
Because
Yay.
over there used to be Washington too. They even have streets still called like Spokane Road and stuff like that. And then
Oh
there
wow.
was a lobby for a panhandle to connect Idaho to Canada. And so that's how the shape cut out a little piece of Washington. I was like, all right, that's gonna be y'all's
Eminent domain.
panhandle.
Eminent domain.
Yes.
I
Yeah,
know, right? It's so
yes.
apropos, right?
Yeah. Isn't that funny? Right on
I
time, right on topic.
know.
All right, so let's go. Let's see how they
Who's
change
gonna
it. Those are
is
great
them
questions.
anybody reading the quote? Who's
It
reading the
is
quote at the top?
difficult. It is
Yeah.
difficult to get a man to understand something when his salary depends upon his not understanding it. Upton
Word.
St. Clair from a book, I Candidate for Governor and How I Got Licked.
Word. All right. Let's go back to tab 2. We already know what the inquiry is. And to finish up the inquiry, apply this doctrine directly to, here you go, y'all. I want y'all to
Yes,
see what I did here.
yes.
Directly to land, housing, redevelopment cases, and all other properties such as automobiles and constitutionally protected rights. I wasn't playing. I told you I was in a zone. I wanted to cover the gamut of it all.
Hey
So let's
man,
see what
I want to
happens.
stop you again, bro, because I'm
Go ahead.
listening to what you're reading,
Constitutional
and what I'm
rights.
getting from this information here is information that would allow even the custodian of the law to achieve the intent of the legislature.
Hallelujah.
That's what
Word.
I'm getting.
Well, you see, that's my bro, man. I'm trying to tell you, man. Kramer gave me. I'm trying to tell you, man. Exactly. That's exactly where my brain was. I'm like, yo, let's get to
It's
the
it's, it's
intent.
meekly
Like,
instructing those who are custodian of justice To
I cannot.
actually interpret the statute to fulfill the legislative intent.
I just am so excited about what we're able to accomplish with that meek instruction, guys.
Yeah, man.
It
Word.
really is reminding all of us of things
Oh, shit.
like
Hot.
we can catch more flies and bees
With less traps.
with sweetness. Okay? We can attract them with sweetness. When we
Word.
show them, because remember, the main reason that people's arguments get recasted and marginalized, I should say, as sovereign citizen nonsense, sovereign citizen arguments, is because we don't show our reverence for the law, although we have it. Do we not? Lawful living?
Correct.
Lawful
Absolutely
living,
correct.
it means
I put
reverence.
the code out there.
Means
Look,
reverence for the law. It means that we
you're not
respect the law.
fiduciary. I'm cut up.
It means we respect the law, does it not?
Correct.
Right.
Yeah.
So why would we frame things in a way that gives the impression that we are who disregards it?
Or who thinks that government is illegitimate.
Yeah, that government itself is illegitimate.
I raised my hand.
Why would we want to do that?
They're getting paid to not understand.
Yeah, but what's our benefit as the victims? Because we still seem to be not ready to get out of our own way for a lot of times.
I guess it's like speaking from emotion instead of the actual facts. Sometimes when something's happening to you or you're being victimized, you tend to speak from emotional experience rather than the facts of the case.
One is
I
not
don't know
able to
what.
decipher words that forms against them as weapons, right? That's what you're
Word.
saying, sister.
Yeah, thank you for that clarity. Also pertaining to another situation that I had. So yeah, training brigade, you got it.
Yes, bad arguments being made, yet off subject matter with logical fallacies. That's where we all suffer from. Because there is nowhere that these emotional stances have worked. Yet for some reason, it is one of the most popular actions and reactions. It does not ever work. There is nobody that said, man, he or she got angry enough, so we just gonna give them the W. Man, he or she was really crying hard today. Do you think we're gonna give them the
In that
W?
case, when you're crying, the judge is saying, the law only allows me to do this, and this is what I can do. Hey.
Said he
We
was
ain't
going to
trying to hear
fire
all
me.
that.
That's the only time they know what the law says they can and cannot do.
Yeah, when you
But
start bawling.
Yeah.
he said he was going to fire all of us.
Jesus.
But go ahead, Asa. Let's get through your.
All right, my bad, y'all.
Here, bro.
So the reply, right, between from Chatija goes, yo, I got a rigorous construction first analysis that tracks etymology, legislative text, judicial doctrine, modern deviation, applied use, right, and applied use exactly in the order that I requested. Okay, so here's a separate. Okay, and Chatija says she'll separate what the Constitution actually authorizes from what courts later
permitted.
So what the Constitution actually authorizes will be found in the enumerated powers of.
No. Let's look at the case law. Let's look at where the judges got it wrong and just keep going wrong because a judge said it.
Yeah. Enumerated powers.
No, enumerated. No. There's no case law to support that we should just focus on the enumerated powers. Look at all this other bullshit law where the attorneys got it wrong and it favors what I want to do to you.
Word. All right. Just compensation, quote unquote. Etymologically, the etymological denotation, which is the original meaning, just from Latin iustus, it denotes lawful, right, according to justice, conforming to objective right,
Objection,
not
it's supposed to be according to
convenience.
just us.
That's what a Eustace looks like, except it's an I instead of a J,
No,
right?
it's supposed to be just according to just us, signed attorneys. Go ahead, bro.
Oh,
Objection
ULC.
sustained.
Wow. In Anglo-American legal usage, just meant full, perfect, and fair equivalence, not approximation. Compensation, quote unquote, from Latin compensare, com meaning together, plus pensare, to weigh, right? So the weigh together, right? Weigh it together, literally to counterbalance exactly. And what you're counterbalancing is the loss of your use of your private property. Thus, compensation meant placing the owner in the same position, neither richer nor poorer, after the taking. Etymological synthesis. Just compensation denotes a lawful, exact counterbalancing of loss, not a statutory allowance, not market convenience, and not governmental estimation.
And probably not unjustly enriching my retirement account.
Mm-hmm.
Did someone say judge?
Mm-hmm. All right. Legislative definition. Constitutional text. Fifth Amendment, operative clause. Quote, ellipse, nor shall private property
Private
be taken
property
for
be
property
taken for
use
public use
without
without just compensation.
word.
Critical construction points.
Yeah, do you think why eat? Way to go, sis.
The clause does not define compensation as market value. So where the heck does that come from? It does not delegate valuation authority to legislatures. Wow. It assumes pre-existing private ownership. Always, guys. It is a condition precedent, not a remedy after the fact. Under
Mm-hmm.
strict construction, anything less than full indemnity fails the condition, which is the same as
Sheesh.
failing a necessary element of a charge or failing a
Correct.
necessary element of anything proper. Early judicial definition of just compensation is C. Foundational holdings, selected samples. No entity wrapping. Court cases are not valid entity types. No entity wrapping. Court cases are not valid entity types.
In other words, it sounds like to me you can't be using some, the what's the entities, the servicers who think they have the right to enforce. That's what I got from that when I first read it.
Okay.
It's
There's a
not
case
wrapping it
called
around that. But go
Van
ahead.
Horn's Lessee versus Durance. You guys
That's
can
from
pull that
the
up.
second volume of the United States reports, page 304, and that's from the year 1795. Go ahead, Ayel.
Compensation must be a quote, full and perfect equivalent for the property taken. So perhaps if they take your 3-bedroom, 2-bathroom house, they should probably give you another one of approximate size. Full and perfect equivalent of the property taken. Another case, Plumlee versus Green Bay Co. from 1871. Any substantial deprivation of use or value constitutes a taking, even without formal title transfer. So, of course, with formal title transfer or with an attempt to formally transfer, all of those things are still considered substantial deprivation of use or value.
Hmm?
Magnolia?
Monongahela. See, there's a spot in West Virginia called Monongalia County, but it's
Mhm.
This one is Monongahela. But go ahead, do your
Yeah,
thing.
Just be
navigation
careful
code
about your tongue, bro.
I know, right? Versus United States from 1893. Congress cannot define away just compensation. Valuation is a judicial question. And this is why they do the taking clause under the eviction policies, guys, under the eviction ordinances that sometimes require you being a bandit, running from the law, that busted into someone else's place and took it over and held them hostage. This is the type of stuff they're misusing. This is the abusive process that they go through to stretch the truth so they don't have to go through this part of the just compensation.
Mhm.
Rule extracted. Just compensation means complete indemnity measured from the owner's loss, not the taker's gain.
Period.
Eminent domain is disfavored, strictly construed. This is part 2. A, doctrine in degradation of common right. Property ownership at common law, it says was a natural right. I'm going to say it is a natural right. Property ownership at common law is a natural right, not a government grant, which is the problem with mortgages from jump. And that's why when people go, well, without a mortgage, how am I going to get a house? You big dummy, go think about it. Go sit in a corner and contemplate
Word.
how you're going to exercise your natural right, since it's not a government grant. It is not a permit from the government. It is not a privilege granted by the government. So then what could give rise to their power to remove it from us?
I
You
got
got
one.
to put it in a trust.
Uh,
Allegedly.
Eminent domain, therefore, operated against the common right, and it was treated as exceptional, not run of the mill. We're going to make 100 people homeless on the first Tuesday of every month.
Correct.
Will we alienate ourselves from the property when we tell ourselves, how will I get food without the SNAP program? Hello, let's talk about it. Newbie Tuesday. We've said this ourselves, or we have family that has said it to us, friends that have said it to us, right or wrong. Without the government program, how will I eat? You know,
Did you
anybody?
save? Did you save those seeds from what you were eating? Did you save the clippings of your green onion and didn't just let it regenerate? Because that's what it does.
You mean I'm not just supposed to throw it in the trash?
Of course, you can do whatever you want. You have dominion. You can throw your dominion in the trash.
Your birthright in the trash.
But look, some people throw their children in the trash.
Can I
What?
sell it for a red
Legacy.
lentil soup?
Wow,
You're
Brenda's got
right.
a baby. Yeah, I'm sorry, but no,
Exactly.
Brenda's got a baby.
And after 3 of these niggas in the trash, they came back. Yeah.
Wow.
They
Wow,
can't
bro.
pay. Hey, like Pet
I was like, I
Cemetery.
said F them kids.
They're like Pet Cemetery in this motherfucker.
Yo, you're hilarious, bro.
Guys, people are asking themselves, let's talk about it. Is that, do we, either ourselves or people we know, they're out here talking about without the government, how will I eat? Yes or no?
Mhm.
That's a
With
fact.
Without the government program, without the government regulated entities, how will I clothe myself?
I
Do
got
you
my
guys,
EBT. I got my
We were
EBT.
programmed into
I got my
into
EBT.
dependence.
without the government, how will I get the bank to pretend to loan me my own interest?
Wow.
And y'all
Sounds like
know this is what's happening, right? Do we know this is what's happening?
Word.
no, that's a
Without the
fact.
government.
Mhm.
That's right. How will
Mhm,
I
in control.
defraud states like Minnesota without the Somali takeover?
Wow.
Hmm.
Did y'all hear that BS going on
Amazing.
with the
Mm-hmm.
I
fake
Amazing.
did.
restaurants, fake daycare, fake? I mean, maybe our friends in Minnesota are right. It is the most corrupt.
It's bad. It's bad. I've been down
Maybe our friends in Minnesota are correct. It is the most corrupt. I think because people were saying that they were doing investigations from other states that led them back to Minnesota. Did y'all hear that?
Yeesh.
They're researching in New Jersey, it led them to Minnesota. They're researching in Florida, it led them to Minnesota. They're researching in Texas, it led them to Minnesota. They're researching in Washington, it led them to Minnesota. And so everybody shows up in
And then
Minnesota
when,
like, what are you doing here? Well, I was just
hey,
researching out in Nevada and it brought me here. And they were like, I was over here in Illinois and it brought me here.
if you research Minnesota, it'll lead you to Kansas.
Oh,
Wow.
probably because that it's not a mistake. They chose Kansas for the Wizard of Oz.
There's no place
Not a
like home.
mistake.
Yeah.
People
there. I
in
found
Minnesota are claiming
in
that
Minnesota.
Minnesota Route 220.
What was that you said, Sharon?
I found New York a lot when I started doing Minnesota digging. I thought that was weird.
Like they borrowed their constitution and stuff like that.
Yeah.
Yeah, I remember. I remember going through stuff like that. You ready? Okay.
All right. You had express judicial statements, sis.
No, we just went over that. We went
Okay.
with Boom and
Oh
Patterson.
yeah, that was
Necessity must
above.
be
So
real.
yeah, it's kind of like yeah, recorded. Okay, canon supplied.
All right, I'll let you guys continue because I gotta step out.
Okay, here we go. Canon applied. Expressio unius est exclusio alterius. If the Constitution authorizes takings for public use, it excludes private convenience, revenue generation, economic speculation, and direct benefit theories. Bro, you want to read the next one? You want to read the ambiguity one, bro?
It says ambiguity resolve against the taker. This was the default rule for over a century. That's Cincinnati versus Wester. Courts must independently examine whether the taking is for public use. Must examine. Now, Missouri, oh, that's another case. Missouri Pacific versus Nebraska. That's a much older case. Then it says taking property to benefit another private party violates due process.
Yeesh. Every servicer.
Taking property to benefit another private party violates due process. Now
Word.
you're saying every servicer, right? And what I'll mention here is that the servicer would be the private party. What I'm plotting here is what's called the state action doctrine. The violation of due process by or when a private party invoke the state powers that it's considered attributable, the deprivation would be considered attributable to the state. So taking property to benefit another private party violates due process. You tired of that sound, right?
Word.
Yeah, the state action that is required whenever a private defendant uses the state power. The statute, the judge is someone for whom the state is responsible. The state action doctrine must be pled in order to survive a 1983 complaint whenever there is involved a private party such as the servicer, as Hassan just mentioned.
Word.
But rule, it says, when doubt exists, the doubt defeats the taking. When doubt
Yeesh.
exists, the doubt defeats the taking.
Please, brother, could you say that one what you just said one more time,
Anytime there's
please?
Mhm.
ambiguity or unclearness or uncertainness, it should go in the favor of the private party in interest.
Which
Thank
would
you. I got
be
it.
the one not wanting their property taken because you have some slave owners, I mean investors.
or the man or woman making a claim on property, whether it's by eminent domain or another claim of dominion. Once it's for private use and there's a private interest, it defeats both public and so-called private business interests.
Word. Well, there's the public use versus public purpose. That's the part I was kind of waiting on right here because this is where we unblur the line in our minds. Anybody else want to read? Or you want to continue, bro?
It says public use versus public purpose. Strict rules of construction. Public use, original constitutional meaning. It says plain meaning from the 18th century. Use equal actual employment, occupation, or enjoyment. Use, I read it again, actual employment, occupation, or enjoyment.
Word.
Public, the people at large, not a select class. Now, public use required, it says public access or public ownership or public legal right to employ the property. You know where my mind is at now, Malika, if you're listening, Asan, the county exercising jurisdiction, property owned by the county, the jails, the
Correct.
courthouse, because it must be for the fulfillment of the intended purpose
Or
of the
the
legislature.
eviction code in
The hotels,
California that's
yeah.
defined under a section that's called real estate hiring or hiring of real estate.
Yeah, yeah.
Like,
But I'm
what?
Word.
yeah. Because the eminent domain principle is trickled down, you know. Like earlier, I think it was on the other tab when it talks about converted for private individuals or something to that effect.
Something like that, yeah.
Yeah. This is what I'm seeing here now. So it's our Malika was talking about a piece of what is called Idaho being cut out to now be Washington. It's the same.
Yeah,
huh?
Washington was cut out to make Idaho. Yep.
Yeah. It's the same principle that
Correct.
continue to exist in terms of the eminent domain, the taking.
Correct.
And then now contracts are formed with private entity, all controlled by the state, governed under some laws of the state. But anyway,
All right.
public use. Yeah, you could scroll down examples. It's a public use the right to employ the property.
And public is the people at large, not a select class. But go ahead, bro.
Class, yeah. Examples. I'm just seeing. Who else is seeing the enumerated powers of the government, the Congress? The roads, bridges, canals, fortifications. Article 1, Section 8, Clause 17. Later, common carrier railroads.
Dockyards.
Yeah, that's what
magazines.
I'm talking about. Hey, B, public purpose, modern judicial substitution. Public purpose is not in the Constitution. It emerged through judicial interpretation in the 20th century and it substitutes indirect benefit, economic development, tax-based enhancement, blight theory. So public purpose is not in the Constitution.
Nope.
I get it.
That's when they brought it into commerce. Huh?
Yeah. Like Malika said it earlier. And it talks about judicial interpretation.
Yep. Judicial corruption, she said.
Yeah, she said judicial corruption. But construction failure. Construction, right? Under this principle here, use cannot be expanded by association with benefit, purpose, policy. The principle. You want to explain this one, Hassan?
I'm just saying it just made me think of every foreclosure. Every foreclosure
cannot be expanded by association with the enjoyment benefit, which is a life necessity for shelter. The purpose for which it is being used for, against the policy for what they have interpreted or created.
Right.
These are different legal categories. Where the substitution occurred, okay, shift focus from use of purpose in blighted area. So it's 1954.
So
So this,
these are the decisions that are guilty,
yeah.
right?
Brennan
Those
versus Parker.
judicial corrupted, these are
I, I,
judicially corrupted decisions. But go ahead, I yield.
yeah, now I'm just saying I would really like to take a look at this case in another moment though.
Okay.
Where the substitution occurred, shifted focus. Okay, no, don't
Oh,
go.
okay.
Yeah, Hawaii Housing Authority. I mean, this just look the entity, Hawaii Housing Authority. I'm just seeing some
Mm-hmm.
conservation purpose or whatever. Mid-KIF, 1984. Approve transfer between private parties to correct market failure. Approve transfer between private parties to correct market failure. So it's now commerce. Okay.
Mm-hmm. Word.
Kilo versus New London. Explicitly acknowledge abandonment of original public meaning. So this was when it explicitly, or this case explicitly acknowledged abandonment of original public use meaning. The
Mm-hmm.
dissent in Kilo,
Well, that's the answer to my question. What year was that?
2005.
Get
yeah,
out of here.
3 years before that so-called crash.
but not even
So
the
are we
crash.
going
I'm
on the
just looking at
modernized time or the 18th century
I'm
definitions?
I'm not this not the little definition. Looking at I think the question even Malika asked earlier, and we were talking about I said 33, talking about 1933, like the new Green Deal, that new should I say revolution? It's not, but for looking at the sequence to 54 to 84, just using these few cases here.
That's 61 years, man, in
Yeah.
30-year segments, 30 to 31-year
Yeah.
segments. But go
Remember,
ahead, I
there was
yield.
a World War II within 45 at least, But coming up,
Mm-hmm.
it says the dissent in Kilo correctly denotes that this interpretation renders the term use surplusage, violating fundamental rules of construction. So it's broadly interpreted. That's what it's saying here, right?
Correct.
Use.
Mhm.
It's full over surplusage. So where modern statute exceeds constitutional scope, urban renewal and redevelopment statutes. So constitutional defects. It says no actual public use. Yeah. No
Jeez.
actual public use.
That's
It's
the foundation of
yeah.
eminent domain. So obviously
Speculate.
it's not
Yeah.
eminent domain what they're doing then. So
Yeah.
that's not eminent domain. What is it? What creature
It's
is that?
not public use.
But go ahead, I yield.
Speculative.
Abuse
Go
of
ahead.
process by
Ah,
administrative larceny.
larceny. Mhm.
Word.
And that's not an AI coinage, right?
You said that's not the A. No, it's not.
No, I'm
That's
just I
you're
know it's
right.
McCreel, man.
Exactly.
I'm just
Exactly.
saying.
Yeah, I
Oh,
agree.
speculative future benefit. Absolutely. Private transferees. Mhm.
Ain't
Legislative findings replace judicial scrutiny. Legislative findings replace judicial scrutiny. I'm not getting this one.
I guess there's
Legis Mhm.
where they may be trying to use certain things legislated in the courts to aid them in their judicial interpretation. That's
Okay.
that's how I took that one, honestly. But
Legislative findings replace judicial scrutiny. I'll continue. It says under strict construction, blight. Definitions are often circular and conclusory.
Jesus.
Yep. Necessity is presumed, not proven. Necessity is presumed. Necessity for whom?
That's why. So that's the goes back to blight because it's blight according to who's thinking.
Compensation is reduced to market value, excluding relocation, Malika. Business goodwill. So compensation is reduced to market value, excluding relocation loss. Business goodwill, subjective value, community attachment. Who was it that shared that clip, son, a few days ago with some guy sitting down at the table with what they're call an Indian, some Caucasian, talking
Oh,
about
I
land?
did. I shared it.
Yeah,
Yeah,
that's what just came to mind already. Relocation
yeah.
lost.
I was like the thief and his $5 accomplice. I
Yeah,
think that's how
yeah.
I titled that.
Housing takings. Public housing, redevelopment zones, and land banks often seize occupied lawful homes. We have seen that throughout time immemorial.
Hmm.
Transfer land to private developers, what they call those, it's, in Georgia, it's called the private enterprise agreement. Justify taking by revenue projections. Wow. Capitalistic. This failure or this fails public use and converts eminent domain into state sanctioned private acquisition. I've been saying this, man. It's the state exercising its coercive powers, being petitioned by private entity, automobiles and personal property. Vehicle forfeiture and impound regime often occurs without criminal conviction, just interested in the property, make a sale. Impose fee exceeding value. Wow, yep. Well, these are clear points though, bro. Retain property permanently
Hmm.
through instruments under pumpkin belly and monongalia. Deprivation of use, that's taking.
That
Retention,
is.
yeah, deprivation of use is it taking. It amounts to
Mm-hmm.
taking. Retention without full indemnity, unconstitutional. No compensation.
Correct.
Can someone
Intangible
else
and
start recording? Can someone else start recording, por favor?
I
Like
am
right now.
recording.
Okay, great. Thank you.
Excellent.
Intangible and constitutional rights. Takings doctrine has been improperly excluded from access rights, labor, licenses, vested benefits.
Yeesh.
Takings doctrine has been improperly excluded from access right.
So
Labor.
so so I'm trying to see now is strategic saying that we can't apply what we're analyzing about eminent domain and just compensation. It can't be applied to intangible and constitutional right. Takings doctrine has been improperly excluded. So it's saying then it should have been included then, right?
Hmm. It should have been included.
Is that what I'm hearing? Because it
The
says
doctrine
that
has been improperly excluded from
it has been
access rights,
exactly.
labor, but excluded. I don't think
Because it should
it's
have been
ex
included. If they take our labor, that's that forced labor.
yeah, that's what I'm saying. It's a forced labor. So if back at the top there it talks about what I just mentioned, the state coercive powers. It's through force. Well,
Word.
and this goes back to what I'll think about here is when Malika talks about the trading with the enemy act, the license. See, and see the word license there as well.
Mm-hmm.
You have to be identified in order to access property as to be used
Sheesh.
as shelter for which your labor will be used to satisfy an obligation of payment.
15 USC 17.
The taking of the land to private developers, it's called, if I may.
Precisely.
Wow.
Whoa. I see the blueprint though. That's what's happening all around, my people. But anyway, yet early doctrine recognized franchises, easements, and contractual rights as property See?
They did. Yep, they recognized it as property. So that means it was included.
Mm-hmm.
Those things were
Mm-hmm.
included.
And this is why the conversation with the attorneys, just to see their comprehension, is very valuable, because it's not that we agree, but an attorney actually brought this point up. They were like, well, where's the case law that says that those things are included in the Fifth Amendment when they're taken, right? By you know, public use, because they're inviting you to a public venue. They're charging us under public public service, right? Public
Word.
servant laws. But this is what they're doing, and the attorneys are there. Like, well, where's the case law? And what we're exploring here is where the court started getting it wrong.
Correct. There you go. Yeah, that's not the only deference that needs to
Which
be
is
overturned,
why
huh?
sometimes we cannot find the case law to support our comprehension of the law as it's written and as it was obviously intended. And they like to use
Mhm.
case law to support when it has changed. But if that change is unauthorized, that negates your use of that case law
Word.
to support your maladministration outside of the legislative intent or outside of the constitutional limitations.
So all case decisions that are deferential needs to be overturned, just like the Chevron shit. You know what I mean? Even though I think the Chevron deference, being overturned sets the precedent for those other deferential case decisions that were made to be overturned. Did that sound right? Did I say that right? I think I said that right.
Yes, yes. And it should be taken on. I know today's Newbie Tuesday, by people with passion to see what is legislatively intended gets done and the
Word.
maladministration ceases.
Word. All righty. Where government? It's on you, bro, if you still want to read.
Where are we? Where government? It says where government conditions rights on surrender. Forced labor, man. Fuck. Excuse me.
Mm-hmm.
Destroys value without compensation. Destroy value. What to say? Time
Mm-hmm.
without compensation. Converts rights into revocable privilege. Your driver's license.
Eesh.
Hey man, the state
Eesh.
exercising coercive power. It exceeds constitutional authority. It certainly does. Applied
So
doctrine. Go ahead.
I'm saying this is a much better framing than they're unconstitutional and they can't do this to us. It's like, okay, you finish hitting the pressure relief valve. Now frame it like this.
Yeah,
Like, you know what I mean?
Right.
yeah.
But go ahead, I yield.
Applied doctrine, practical framework. Any eminent domain action must satisfy all four. And this is like saying the four elements of a contract: actual public use, strict necessity, full and perfect indemnity, just compensation, I'm
Word.
saying.
Correct.
Independent judicial review. Independent
Correct.
judicial review, not just judicial review. Independent judicial review. Failure
Word.
of anyone equal unconstitutional taking. Hey, I'm talking about it.
Boom.
I'm talking about it. Actual public use. Strict necessity. That's the ministerial duty that is required. The necessity.
Word.
Failure of anyone equal.
Someone's asking if we have time for an emotional outburst.
Go right ahead. Make your emotional
Go
outburst.
ahead, McGarvey.
Greetings, family. How are you all?
Peace, peace. What's good with you?
I'm maintaining, out here trying to, what you just said was like, yo, I got a correspondence from a judge, and he was like, although the law does say that I'm supposed to do this, I'm not going to do this. And I was like, I had that emotional outburst that you just did. It's unconstitutional. Okay. So just an update on the house, and I'm driving right now, but the realtors, those N-word realtors tried to come and send a locksmith company to change the locks at the crib after they had already taken the auction and the listing down. And so when the people got there, they was like, "Oh, these people are gonna evict you, and you can't be here, and I got a work order." And I'm like, "Bro, that's still trespassing. I don't know like how the work order makes it not trespassing. But in any case, afterwards, I sent an email to the Attorney General, the Real Estate Commission, and the realtor, and I asked like, "Yo, who is like this guy is doing this? So is he doing this under a license or is he doing it on his own? I just want to know." And so the guy, I got a response from the realtor company saying, "Which property?" And it's like you already got an email from me talking about, with the list pendants and all that information. So you know exactly the property. And then there's only one probably locksmith that got turned away from a work order that you had yesterday, brother. You know what I'm saying? So it's got
Word.
to be me. But in any case, like, okay, so that
It's
was
all
that.
it's
So,
always good to include the address in the correspondence so they don't have to go
mhm,
look for it or ask you for it
right.
or delay because they're trying to match things up. Because remember, these folks are running a mill. So our individual homes and property is our primary business. It's not theirs.
Hmm.
They're just it's literally run of the mill.
And we're at the
Okay.
end of the document, so we're gonna finish this up, and then we'll take questions, guys. You that got your hands up. Just want to make sure
Yeah,
y'all know y'all
but go ahead.
acknowledged.
I want McGarvey to finish getting
Yeah, of
his
course. Yeah,
outburst out.
absolutely. Yeah, go ahead, bro.
Okay. Yeah. So then the attorney general didn't respond. The realtor said which property, and then the real estate commission says if you have a problem, consult law enforcement. But if you feel like there was a violation, you have to fill out a specific form to tell on the realtor. But
Yeah,
I'm
it's like a
already
tort claim.
prepared.
It's like a tort claim form. So go ahead and fill that out.
Realtor
Okay,
grievance. They like
okay,
those.
I will definitely get that done. And I was actually working on a claim. Like I wasn't even gonna do that, but because you said to do that, I was just gonna send a claim or the notice of liability and intent to sue. And then also, I went to an Infinity
Yes,
dealer.
you do want to send the realtor or whoever the agent is that notice of liability and the necessity of good faith, etc. You absolutely want to send them that. But separately, you want to
Mhm.
always complain on them to their licensing agency in whatever tort claim or equivalent they might have.
Okay, perfect. So I did send them like prior, like when they had it listed online, I did send them like a last correspondence, like, yo, if you don't take it down, I'm going to sue you. And then after that, they send somebody to the locks like a week later. And so I just thought that was pretty foul. And then the last thing I'll share just quickly is that, this Infinity, dealer I was dealing with, I got them to give me the information that I have to provide X amount of doll hairs, and I have to have an ID and an SSN and so on and so forth. And then I had told him like all that doesn't apply to me. And then so when I got to the higher ups, they said they was gonna have attorneys reach out. And then I didn't hear anything. And then I sent an email today. And then this guy here, hold on, I'm gonna just pull over. This is kind of crazy, but I do want to show this email though, just to have you guys see. Is it okay if I share my screen, guys?
Yes, I don't know who can allow him to share his screen, but go ahead if he pulls over.
Yeah, I just pulled over. Just on the side. Okay, here we go. Screen, entire screen, screen, so, okay, I'm assuming you guys can see. Okay, so this is what I got today from the dealership. And so I haven't really taken any time to go through it, but basically I was telling them I'm not one who qualifies to pay or have these requirements, and I'm not an
Yeah, but
quote unquote owner.
you can't keep making those claims. What you have to
Hmm.
do is express that claims were made about what you have to do and what you
Okay.
are supposed to have and etc. And you
Hmm.
need to see their proof, okay?
Okay, okay.
That
Yes, sir.
what
Yes,
they're
ma'am.
talking about applies to a transaction with you, not us always the one pontificating our claim like, oh, that's not for me, and then they're going to be like, well, yes it is, and you're like, nah, and then you're just back and forth with foolishness. If they're
Okay, okay.
alleging that this is what applies to yourself or transactions with you, you have to keep the onus where it belongs, which is on the entity making the claim, that they can discriminate against you or force you to be of a certain capacity. What allows them to do that is always the question.
Word.
Okay. Thank you very much. So that was my little emotional outburst, and anything else as far as the house goes, I'll keep you guys updated. I appreciate it.
Gratitude, gratitude.
Gratitude. Excellent, bro. All righty, let's finish up the last parts and then we'll get to your hands raised. All right. Bro, you already read A, you're on B now. Diagnostic questions.
It says that diagnostic questions, any case, who actually uses the property after the taking?
Word.
Is access legally enforceable by the public? I'm thinking about, like, for those who might have lost property in such an instant.
Uh-huh.
Hey, is the benefit directive or speculative? Speculative. Is compensation measured by owner lost or government convenience? Was there any compensation whatsoever?
Oh.
Would this taking have been lawful since 1791? What's that year again, bro?
In 1791 is the ratification of the Constitution.
Okay, yeah. Would
That's a
this
gut
taking
punch.
have
Yep.
been lawful in? Okay.
Yep.
If the answer to the last question is no, the statute likely exceeds constitutional scope, as they often do.
Eesh.
I think there needs to be at least one declaratory action filed in every single state about this exact thing.
Yeesh. All right. Core conclusion.
Eminent domain was never a general development power. It was a narrow, disfavored exception, strictly limited by those four elements: public use, necessity, full indemnity, and judicial resistance to expansion. Pigpen. Modern redevelopment regimes survive only because courts relax construction rules, not
Oh.
because the constitution changed. So
Oh.
they exercise great discretion.
So don't come in your office and show me that the Constitution was expired. You want me to come into your office and see how you're relaxing on the construction rules. That's quite the lazy
Because
boy.
you're using the rules too strictly.
You're over applying. You're over
You're
applying.
over applying the rules, bro. That's not fair. You're supposed to let me bend them or break them every once in a while.
Why? Because you're relaxing on the motherfuckers. You and those courts, you court officer, you, huh? So let's get to your hands up, and while you guys are having your hands up, I'm gonna look for that street cop training video just to give you a brief, because Malika was like, you guys need to see
but but
that.
but before you even do that, Hassan,
Okay.
it really goes back to the genesis of the first tab, though.
Okay, hold on. That's right. We can't finish this thing off without going right there. I yield.
Me too.
I think we have to keep that on the forefront of all of our communications. And I think this is especially important for our newbies because when we're new and we first start to stand up for ourselves, our expectations are, it's almost like you can't help yourself. People are like, well, are they going to respond? Should they respond? What will they say if they respond? And then we sometimes get into, well, they're ignoring me. They're not. Keep this in mind.
I
Think,
want to.
put yourself in their shoes or anybody's shoes that's being pointed out. Think about whatever your job is or may have been. If somebody would have came to you and said, after you've been doing it for 2 years, 5 years, 8 years, 12 years, hey, did you know that you were doing this illegally?
I
Think
got a
about how you would
newbie,
react.
something I can share real quick that happened to me.
What? Yeah, bro.
And I filed a
Hold on one
judicial
second,
note.
Don. Let's let
Yeah,
Trading Brigade get his word out, and then you
Yeah,
can go.
yeah,
Go
sure.
ahead,
yeah,
Trading.
yeah. Just in the spirit of this here, I want to ask a question. It says the same quote: it is difficult to get a man to understand something when his salary depends upon him not understanding it." And I want you guys to, while we're writing, take a few minutes to think about what's the next line you would insert here in sending any communication to a agent of the state.
Like what will you say
What?
after that
Yes.
quote?
What would be the next line? and dealing with an agent of the state.
Here is your notice of liability and intent to sue.
Nah, I'm not. I'm not.
Whoa,
I'm
whoa,
saying
whoa.
Kick you in the face.
Here's your good faith notice first before that, I guess.
You can understand,
my
yeah.
line is
If you do not understand, hire a competent lawyer.
my line is
You guys are
govern.
Just
Due
give
to
us.
the false process, I no longer want your benefits.
They're just going for the
My
juggler.
line would be that government derive their just powers from the consent.
Wow.
Somebody want to finish
Of
it?
the government.
Of the
Of
government.
the
governed.
Where
ED.
But
did
that
I?
starts off with the protection of property is the consent of the governed.
It's the protection of, they're supposed to protect the rights of all people.
Yes, and that's what I'm saying here. It is difficult to get a man to understand something.
That something is the protection of the rights of all people, is what
Or whatever
Gotcha.
their true function is in the scheme
Yes,
of things.
yes.
Period.
Gotcha.
Public, they are public trustees of the public
Because
trust,
it
and at
becomes
all
whose
times are amenable.
property. It becomes whose property are you pledged to protect? Person's property? Because that's what it seems mostly that they're doing. They want to kick us out of McDonald's. They want to kick us out of movie theaters.
Right.
Right? They want to arrest us when we walk out of grocery stores with our dominion. But
You have lost my trust, so take me.
why do they interpret their duty to protect property of protecting property of persons?
Wow. So can
Because
you
not
replace?
only do they.
Go ahead.
Go ahead. I'm sorry. I was going to say, not only are they taught that way, likely from like not actually reading the procedures, but actually going to training. And this is what they taught me in training. Not that I read the book. And also, most of the people capitulate. They agree that, yeah, I'm not supposed to go in there and grab my dominion out the stove.
And can we replace? Go ahead.
I was just confirming. It's a miscomprehension of both the antagonizers and the victims. And that's my main goal for people, because too many communities, they harp so much on look at what the agents are doing, and therefore the people in the community take no personal responsibility. They go, oh well, everything is corrupt and everybody's corrupt. But we are winning in every state, guys. I hope everybody here has realized that. There's no state that we've found that's like nobody has won anything.
I just pulled up and I'm already winning, y'all. I'm sorry.
That's
hilarious. Indeed.
That's right.
Let's do some like amplifying, right? If we were to put some brackets somewhere, it is difficult for a man or a woman on the clock to understand their ministerial duties.
That is true.
When their unjust enrichment depends upon them not understanding.
Yeah, that is absolutely more accurate.
So, hey, I just want to let everybody know I sent a judicial notice from that arrest that happened a couple of weeks ago. Excellent. And they put it on the record, and they treated it as a motion request to dismiss. I didn't include a motion, but that's how they treated it. And they're giving the prosecutor 10 days to respond. And that was on the 23rd. And hilariously enough, they didn't respond on the record, but they are being, what do you call that? Posturing. So they sent me a letter stating that you are being charged with this, that, and this, and that, and that. And so that's not on the record. And so after the 3rd, we'll see what happens. But so far, there's not.
What was the date of that notice that they sent to you?
The 23rd.
Okay, so it got crossed in the mail.
What do you mean?
If your thing wasn't filed until the 23rd and they sent the communication on the 23rd, that doesn't necessarily mean.
My notice was sent on the 17th. It was docketed on the 19th in the court. And on the 23rd is when they responded. So they're posturing.
Okay. Got you.
Well, and in their letter too, they said, please contact us.
Aww.
Wow.
Yeah, don't go to court.
Yo,
Just
that's
Who
wait
we?
for it to
surrender.
work it
That's
out.
surrender.
Who
That's surrender. That's
For
That's
surrender.
real.
awesome. That
And then
absolutely is surrender. I agree, Trading
and
Brigade.
and and this is what I'll say before we get to Josette and Ashley. What I'll say is from us looking at and hearing those attorneys talk about us, on TikTok and whatnot, right? What I'll say if and when you make that communication, if you decide to be bold and do it off of the four corners of the paper, know that they are measuring your competence of the document you sent them. Period.
I
That's what
agree.
they're doing. Never let that leave your sight and stand on your fucking square.
Yeah,
Interestingly
that's for
enough, too,
everybody.
Facts.
when I went down to the courthouse today to get the minute entry, because I seen it online, I'm like, well, what's going on? And so I went and got it, and it just verified it. But oh shit, sorry, I forgot what I was gonna say.
Does it
My
say that
bad.
they have to answer on the record?
Oh no, I went and got it. No, there was no answer. There's no
No,
answer.
no, 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 no. The minute order that says they have 10 days to reply, does it
Yes.
say that they have 10 days to reply on the record?
They have to respond. They have to respond on the record.
I'm just asking if the order specifically said that. That's all.
Hang on, but it,
It's okay
if
if you don't have it. I was just
It's
curious
all
if
good,
you
yeah.
if
if
that's
the
what it said.
judge if the judge says that they have to respond, it doesn't say that it has to respond in person. He's saying you got to respond on the record. He doesn't say specifically, but that's implied,
Okay.
correct?
I was just wondering if it was specified.
Okay, so this is it.
It
This is
is
the time.
it is, in my opinion, implied, since it's also saying that they interpreting it as a motion. Because if they're since they're interpreting it as a motion, it is correct, that the answer would be on the record, because if it's
The
not, then
defendant
it's
has
not a
filed a
reply to the
motion.
motion.
The defendant has filed a motion to dismiss for the above referenced matter. The court will give the state 10 days to respond.
Okay, yeah, that's on the record, guys.
Okay,
Because they're
excellent.
calling, if they're labeling it as a motion, motions require on the record responses.
And they
So
have
Indeed.
whatever they
counsel,
sent
city
you,
prosecutor for the plaintiff, and they have me as improper.
okay. And then did they the response that you got on the 23rd, was that mailed to you or emailed?
That was mailed.
Okay, and what does the postmarks, when does it say it was mailed? Because what I'm trying to see is if this is an actual response to
September
what you
23rd.
what if it was an actual response that they sent to you,
It was a
or
it was a
not a
boilerplate.
response, but like, you know what I'm saying, like a communication
It
that they
was
were
not.
already sending to you and it just got there on 23rd, or
No,
if
I don't
it
think
is
it.
something related to what you filed.
I don't think it was something that they were already sending me. First of all,
Okay.
because when I gave the judge my address, I didn't give him this address, and so then, but when I sent, and that was in person, but when I sent the judicial notice, I gave this address. So, but they're certainly posturing because they got the order. They got it on the 19th. They responded on the 23rd. The 23rd is when I'm looking at the dot. Excuse me a second. Took a screenshot over here.
Thank you, Josette and Ashley, for your patience.
Yeah, that's
I'm sorry,
awesome.
guys. I'm sorry, guys. But anyway, we're winning. It's good. I'm
Yes,
excited.
that's very good.
Indeed, gratitude. Josette, go right ahead, guys. Go right ahead, Josette.
All right, thank you. Mine's real easy. So the Tennessee Department of Revenue, this piece of mail has been jumping back and forth between them and the post office and me. And it seems like the post office is not returning to sender. They're just returning it back to me, because the first time I returned it, it actually went back and they sent a new one that didn't have my writing on it. But now they've been sending it back with my writing on it. So it seems like the post office is not doing what they're supposed to do. What say you guys?
Let's see what they say. Write them and ask them their procedure for return to sender and where you can find it.
Oh, you're cutting out. I didn't hear you.
You and them together will say, this is what the code says, and this is what actually happened. What does this mean?
And send that to the post office? Do that with the post office?
Yeah, that's
okay.
I mean, you either a phone call and or a writing. It absolutely. You have to get what are the rules for return to sender. Does everybody comprehend why I'm suggesting
Correct,
that?
because you're giving them an opportunity to throw themselves under the bus when they go, we don't follow those rules.
Correct.
We just do it this way. We just be winging it.
Right. Yeah.
Yeah, because they don't like
We want
returning to
them to be
sender.
like, yeah,
They
that's
left
the
mine
rules,
in there
but we're
too.
just winging it right now.
Mm.
Sorry, Wolf.
What'd you say, bro?
I said it seems like they don't like returning to sender because they was leaving mine in the mailbox too.
But they don't have that. We don't need their feelings and what their dislikes and all that nonsense. What does your duty say that you're supposed to do?
Okay.
Are you supposed to act as judge and jury and determine that I'm supposed to communicate with who I'm returning to sender at?
Right.
Where do they get the discretion to bully us into receiving mail that we have labeled return to sender? Where does that authority actually come from? Is it legislated and constitutionally restricted, or is it an expansion?
That word is so funny. Oh, Jupiter. Look how you're being misused. Shout out to all my astrologers that are here. You know why that joke landed just now, right? All right, y'all. Josette, anything else? Anything else you wanted to add to that, or are you satisfied with the reply?
Yep, that works. Thank you.
Gratitude,
Yeah, find
gratitude.
out with them. That's crazy. We're just gonna force you to take these benefits. You better get out my face.
Word. Ashley.
Okay, can I share screen? Because I want to
Give it a
go through
shot.
this document real quick.
Be like OJ, take a stab at it. See if you can share.
Entire.
That's
Too
a
early.
terrible joke.
Too early for OJ jokes. Come
It was
on,
never
guys.
confirmed.
Terrible.
It was never confirmed that the glove fit.
Exactly,
Exactly.
coach. Let them know.
Exactly. That's why it's funny, because it's not true. That's why it's funny.
And you must acquit.
Okay, it's making me mute when I share screen.
What?
Yeah, let me try again.
Oh.
I
Sounds like
hit
a
also share audio.
word.
We
Yeah,
like
man,
show and
it's
tell.
still making me go mute. What?
Yeah,
We
that's
like
banana.
show and tell.
Okay, so can I just read it? I don't know. I want you guys to see it too. Okay, but just guys, let me know if I'm on the right path.
Can it be emailed what you're trying to share?
Yes, I can email it real quick.
Okay,
Who
just
shall I
email
email?
it to, hold on, because I was going to share that street cop training video because I already had it queued in the chat. So now let me put my email address off dutyalibi@gmail.com.
Go. Or
Did he say K-pop? Oh, street pop.
Offdutyalibi@gmail.
Street cop training.
Street cop.
K-pop, street pop, same pop.
What in the Korean boy band are you talking about? Let me stop. Stop.
All right, sending it now. So basically, this is like the information that I have been learning from you guys, and that I have like etched in my brain, and also with the information that I use from my findings of the unindicted cases. So I just wrote something to send to the judge. So check your email, Hassan.
I am definitely waiting on the inbox to show it. I'm actually sitting here in my inbox just waiting
So
for
go
it.
ahead and cue the street cop stuff while that email's coming through because I think everybody needs to see that. We're a little bit over time. So I appreciate you
Okay.
guys sticking with us.
Oh, you said as soon as you said that, it came through. All right, so forgive me. Let's all right, hold on, Ashley. Here you go. And then I know we're overtime, and maybe we can get a taste of the street cop joint after Ashley shares this, if
Thank
Malika
y'all
allows it,
so much.
okay?
Yeah, let's go,
Indeed.
y'all. Let's do it.
All right, here we are, right?
All right. So private communication, because I don't want to put this on a record. So to the judge, one comes in good faith with this private communication and notice of liability and intent to sue. Oh, this is the old one. That's the old one. I'm going to read from mine, but you guys get the
Okay.
gist of it. It's pretty much the same.
Okay.
One must meet requirements, capacity requirements to be a defendant in this court's proceedings. Felony charges against one are not indicted by a grand jury, and there's no inter-party who may verify the act of a crime against them. This or any court's claim of any kind in this district court is void ab initio due to the following factors. One, pursuant to Article 1, Section 2 of the Texas Constitution, all power is inherent in the people, and all free governments are founded on their authority and instituted for their benefit. The faith of the people of Texas stand pledged to the preservation of a Republican, not Democratic or democracy, form of
What?
government, and subject to this limitation only. They have at all times the inalienable right to alter, reform, or abolish their government in such manner as they think expedient. Two, the record does not reflect a partnership or other unincorporated association or an individual doing business under an assumed name with my name in this state, and claims from this court mistakenly identify one as a partnership, assumed, or common name doing business for the purpose against one's substantive God-given rights.
Interjection.
One, I'm sorry.
I said interjection. Footnote number 1.
Okay. Okay, put in a footnote.
I'm just saying footnote number 1, Upton Sinclair.
Okay. I'm gonna get to that. Hold on.
Go ahead. Continue.
One does not breathe
He's
breath into
suggesting
one's.
to make a footnote and make the footnote the quote from of Upton Sinclair.
That we went over
I
today.
have it at the bottom, but he has my
What?
old version, and I've updated it. But it's there. It's there.
Yeah.
It's there.
Way to go. Way to go.
One does not breathe breath into one's lungs as a privilege given by the state of Texas judge. 3, the public agents conferred with the ADA to produce charges for alleged crimes, but the ADA did not produce any oath of office, contract, or any obligatory instrument/agreement of one's own consent that binds ones to the rules of the municipal penal, state, or federal code as a legal entity on the record. This mistake of misidentification must be corrected immediately as it subjects one to harm presently. 4, one's private property, passport card, private conveyance plates, time, talent, and treasure were taken under threat, duress, and coercion without first being given just compensation. Number 5, rule pursuant to Texas Rule of Civil Procedure, Rule 12, a notice to show authority has been sent to attorney, and her attorney has yet to answer. 6, a plaintiff must have standing for the court to have subject matter jurisdiction to decide the merits of the plaintiff's claims. See this case law. Number 7, one does not act as a defendant liable in the capacity in which one is sued. The record does not reflect that one was engaged in any business or occupation of the state during the time of acts or omissions. 8, one does not intend to be represented or representative to, of, and for any legal or commercial entity in this or any other venue. Number 9, e justum generis is a lawful requirement for any action to commence against one who is doing business for the state of Texas. Number 10, if an agent, officer, or assigned of this court does not recognize their constitutional boundary, they are liable for claims of damages for deprivation of rights under color of law and conspiracy to do so. I do not wish to waste any more of my time or the court's time. 11, due to my religious beliefs and the foundations of Article 1, Section 8, Clause 14 of the Constitution, Which state Congress makes rules for the government? I will not participate in any other quasi-judicial proceedings without the correct and proper record that reflects instruments of obligation for one to perform any duty that commenced any action in cause numbers, blank, blank, blank. 12, pursuant to the Criminal Code of Conduct, Title I, General Provisions, this section states that no citizen of this state shall be deprived of law, liberty, property, privileges of immunity, or in any manner disenfranchised except by due course of law of the land. 13, pursuant to this same title, this section states no person shall be held to answer for a felony unless on indictment of a grand jury. This the conclusion. May all charges be dismissed sua sponte, as the record reflects no elements of a lawful claim with due process of law, real parties in interest, or injured parties to be verified. In this case, if this case is not removed from the docket and all charges dismissed, criminal and judicial complaints will ensue for deprivation of rights under color of law. Footnote: it is difficult to get a man to understand something when his salary depends upon him not understanding it. Upton Sinclair, respectfully submitted. Okay, the end.
And to answer Trading's question in this particular case, my next line would be govern yourself accordingly.
Yes, ma'am. Got you. Changing it now. All right. Did that sound okay? Does it sound like I know what I'm talking about a little bit?
It's well read. Yes, yes. Sounded like you
I
had your thoughts together.
I like how you drafted it before class, but it fit right in with what we were talking about in class.
Word.
Not being allowing ourselves to be subjected to forced labor, recognizing that it is still a taking.
The time of one's time.
Yeah.
To attend a circus for which you will not be compensated.
Ooh, attend a circus.
Hey, you trying to get me for contempt.
Only agents can be held in court.
Right.
But let me ask the question. Isn't it under an act?
Correct.
The act prescribes the person.
When you say act, you mean like act of Congress?
Act of the Texas legislature or Texas General Assembly, whatever it's called. Yeah. The state version.
Right. It might be like the same public service or public, something like that act.
It's under some act, and the act prescribes the persons who are eligible to participate.
It's a deprivation of a use of her time, thus equaling a taking. No?
Mm-hmm. Yes, it is.
Apparently, this is a very hot topic because when I first mentioned that in one of my TikTok lives, that was like a new perspective.
In October 2021.
Sorry, go ahead.
It's a different perspective from like people have not found the so-called case law, guys, that supports that your labor and your time are protected property under the takings clause. So so I saw KMB was in the chat and she was like, why do they rely so heavily on case law? That's a great question. And the answer is because the court's opinions are supposed to reflect the principles of the law. So you go to case law to see how the principle was argued on either side.
And not how the principle was deferred from.
Right. But even that deference was created with a caveat. It wasn't actually created to disparage. It's just being used to disparage. It's like a hammer was created for a specific purpose. Yes, guys, everybody can realize it has a way to drive nails in and a way to remove nails. That's the specific purpose it was designed for, correct?
Correct.
However,
not to bust people's heads wide open.
It can be used exactly. It could be used as a paperweight. It could be used to bust somebody's head open, right? It could be used for a lot of things. That doesn't mean that the use of it or the perversion of its original intent justifies anyone perverting it and then using it in its perverted state, and then using the frequency and the normality of that perversion of being a defense to not doing it as it was originally intended.
Correct. Intended use. Look at that. Intent and use. Look at that. Hey. That is so dope. All right. I'm a yell.
It's something that I'm exploring too, bro. I'm saying our intent is not known to the record, on the record. Like even some like foreclosures.
Okay.
Well, Malika, you have a document and a declaration of intent or something to that effect, right?
Yeah.
But like the intent through the transaction. But we'll talk about it. We'll talk about it tomorrow. No worries.
Okay.
Indeed. All right, here we go, y'all.
In October 2021, about 1,000 police officers attended a private police training conference in Atlantic City. What we found was really disturbing.
I'm not sure the guy who's recording you like, I am not a citizen of the United States under Act 1260. Shut the up, right? About to get pepper sprayed, tased, windows broken out, motherfucker.
Welcome back to the Civil Rights Lawyer channel. In this video, we are going to talk about this report that came out in New Jersey from the acting comptroller that looked into this private law enforcement training firm, training approximately 25,000 to 30,000 cops nationally on an annual basis. Well, they investigated this one particular course being taught, the Street Cop Conference in Atlantic City, New Jersey. Almost 1,000 police officers showed up to be trained. And now, according to the Attorney General of New Jersey, all of these officers have to be retrained because there were problems.
I've made it very clear to all 38,000 sworn officers and their leadership that no one should be attending street cop training.
Before we get into the specifics of what they taught that was wrong, legally speaking, here's a few of the greatest hits from the conference.
I don't want a hero's exit. I don't want to fucking die at like 91 with hookers and cocaine around me, you know? So, hey, we watched your body cam videos. We don't think you got a voluntary consent. Yeah, here's 7 pieces of case law, fuckhead. Stop trying to back the 19-year-old dispatcher.
I would be remiss if I didn't remind you or let you know that I have a 3-inch dick.
I'm not the one with a 1-inch dick.
I watched this car come off the highway, and I fucked the shit out of the female driver. She doesn't want to fuck me back, though.
And when I began to research the guys involved in teaching these cops, it's no wonder why they now have to be retrained. Look at this one in particular. This was something he said during this conference.
In the South, it's the Wild Wild West, South, wherever. You don't believe me? Run from Georgia State Patrol. Run from me. Somewhere along the chase becomes neither confirm or deny there's some videos out there with me doing just that.
Obviously, what is the first thing that I went and did when I heard him say that? I searched for the video. Check this out from just a few months ago.
First on the news at 6 o'clock, a Reserve West Baton Rouge Parish Sheriff's deputy who shot into the back of a fleeing car is facing charges tonight.
Sean Pardazzi was fired in February, months after the initial incident took place. He's now facing charges of illegal discharge of a firearm and obstruction of justice.
Vehicle in park.
And what about the main dude? Well, I looked him up also, Dennis Benino. He's the one who said he was going to tase the guy for filming him.
Shut the fuck up, right? About to get pepper sprayed and fucking tased. Windows broken out, motherfucker.
Well, on Street Cop Training's website, he has this bio of himself, where he says that he worked in one of New Jersey's largest municipalities in 2005. He has received multiple awards, including but not limited to life-saving, meritorious service, Mayor's Award for Excellence in Public Service, several letters of recognition, leadership awards, and certificates of appreciation from several law enforcement organizations, and he now leads one of the fastest growing LEO education companies in the country. But CBS News had this headline about him. CBS New York investigates controversial police trainer was disciplined for alleged racial slur, other incidents. They ask, how did a former New Jersey police officer who was disciplined 3 times in a period of 5 years go on to train thousands of officers while charging local governments thousands of dollars? This is the same guy.
CBS News discovered the founder of Street Cop, Dennis Benino, was a street cop himself in Woodbridge Township, New Jersey. Public records revealed Benino was disciplined by the department 3 times in 5 years. In 2015, 3 women accused him of using excessive force and racial bias. Woodbridge Township paid $50,000 taxpayer dollars to settle before it went to trial. Benino never admitted wrongdoing. Woodbridge police say he retired from the department at age 33, weeks after that lawsuit was filed. Then he went on to create Street Cop.
So there's some of the background on likely why this training is problematic. But looking back at Mr. Benino's bio, he ends it by saying his personal mission is to ensure the safety of law enforcement personnel, citizens of the world, and to ensure police officers are well versed in understanding and abiding by the Constitution of the United States.
We investigated this 6-day conference hosted by a private company called Street Cop Training. Instructors taught unconstitutional policing practices, teaching officers to stop motorists without a lawful basis and to illegally prolong traffic stops.
Have a day where you go out and go, I'm going to pull over 20 people in a row for the sole purpose of asking them a series of questions and make up your own questions. Something as simple as, hey, how you doing? Where you come from? You know, hey, where you going? Be real friendly about all stuff and just see how people answer questions. You will learn general baseline.
So that was Officer Tommy Brooks of the Boston, Massachusetts Police Department explaining his methodology for stopping motorists. The only problem is that's unconstitutional, what he's saying. He's going to stop just the first 20 cars. Police are not allowed to randomly stop people for no reason. They are also not allowed to stop a person or a car for arbitrary reasons or based on an inarticulate hunch or gut feeling that the driver or passenger might be engaged in criminal activity. Basic Constitutional Law 101.
We've all seen the videos of Kenny Williams with him sitting in the driver's seat. He's finger fucking his computer, really just playing Tetris, not doing anything. And he's asking them very simple questions in the midst of, his investigation. Oh, so who's that in the car again? Oh, where'd you guys say you're going? You're going for a long time? I have family out that way. Making up a story and trying to engage them in a casual conversation.
So that's Brad Gilmore of the Bergen County, New Jersey Prosecutor's Office, advocating for prolonging motor vehicle stops in violation of the Fourth Amendment. During a vehicle stop, police officers are allowed to make ordinary inquiries incident to the stop, such as checking the driver's license, car registration, and insurance, and running a check for outstanding warrants. While making those inquiries, officers are allowed to ask questions of the driver and passenger, even if those questions are unrelated to the justification for pulling over the car in the first place. But officers are not allowed to perform those inquiries in a way that unreasonably prolongs the stop. Absent some other justification of further detention, once the mission of the stop is complete, whether it's issuing a ticket or a warning, the police officer must release the motorist to go on their way immediately. If the officer detains a motorist for any additional time in an effort to develop additional reasonable suspicion to justify a search or further detention, or to request a canine sniff, the stop becomes illegal. And all evidence obtained from that point forward, whether guns, drugs, or incriminating statements, likely will not be admissible in court. Again, basic Constitutional Law 101.
In Indiana, speed limit for trucks is 65, cars is 70. There's no fucking way that any car should ever be behind a semi if they have the ability to pass it. So when you do that, if you're coming through Indiana, I'm gonna fucking stop your ass. Like, he has the whole left lane to pass his fucking semi, but he's gonna sit right behind it. It makes zero sense. It's not logical.
So that's Instructor Kenny Williams, a sergeant with the Hobart Police Department in Indiana. And that was him, you could see in the last clip, unlawfully prolonging a stop by sitting a driver in the front of his patrol car and pretending to type on his laptop the entire time that he has the driver sitting next to him. But rather than conclude the stop at that point, Williams continued asking the motorist questions and then explained to the conference attendees that he ultimately found a large quantity of drugs in the car. However, on the facts shown, there was not a lawful basis for Instructor Williams to prolong the stop at that point. By the way, somebody get that guy a lawyer. I mean, he's probably sitting in prison somewhere, and the police officer who arrested him has admitted to 1,000 other cops and the internet that the entire stop was illegal, violation of the Fourth Amendment, and therefore the drugs that were seized in the vehicle should have been suppressed and he should not be sitting in prison. And here, Kenny Williams states that in Indiana, the speed limit for trucks is 65, but for cars it's 70. And in his opinion, there's no effing way that any car should be behind a semi if you have the ability to pass it. If you're coming through Indiana, I'm going to stop your ass all the effing time, even though you could be totally legit. In support of that point, Williams showed video footage where he pulled over a car that was driving behind a truck and committing absolutely no crime or traffic infraction. The video proves that. So he makes a stop and he documents it and he teaches it to other cops where he's literally violating the Fourth Amendment by pulling somebody over in the complete absence of any reasonable suspicion that a crime or infraction has been committed. Again, basic constitutional law 101, not only being taught incorrectly or ignored, but teaching them to violate the Fourth Amendment. But wait, there's more. Now, some of this is less important than the constitutional law stuff, but you start to get a picture of why cops behave the way they do when you see how they act behind closed doors and how they teach each other. Remember, the audience is interacting with all of this very positively, as far as I can tell.
They denigrated women and racial and ethnic minorities.
I don't want heroes exit. I want to fucking die like 91 with hookers and cocaine around me, you know? Like, why wouldn't that be your goal and objective? Like, I'm on vacation in Colombia, money, and these girls like are not as wealthy and they need to do things to make money.
If you're trying to get a little booty, nanny, poontang, whatever the hell you call it, okay? There's an approach. You don't walk up and say, "Hi, what's your name? How old are you?" Sounds like casting couch, doesn't it?
They promoted a warrior mentality and glorified violence.
There's nothing else I'm good at. I love violence, I love fighting, I love shooting, and I fucking love freedom. It wasn't that long ago that we were drinking out of the schools of our enemies. Like, you know, like, I'm gonna fucking murder this guy, then I'm gonna take his head, then I'm gonna cut his head in half, and then I'm gonna boil his skull, and then I'm gonna drink out of that skull.
To be clear, what Tim Kennedy is saying could be perfectly appropriate to an audience of people training in MMA or Brazilian Jiu-Jitsu, or even high school kids on a football team. I really wouldn't even have a problem with that. But here we are talking about training police officers, agents of our government, to interact with us American citizens.
They belittled internal affairs.
Get kicked in the dick one too many times, when we get in trouble by IA, when we lose our motivation and inspiration. I harped a lot on all the negativity. How many times I got kicked in the dick because they didn't want me to go out there and hit a trap, and they didn't want to hit money, they didn't want to hit me kilo. I hit 15 kilos, I hit 300,000. I'm still getting yelled at. I'm still getting yelled at.
Somebody with some kind of fucking thing on their shoulders or neck collar or fucking whatever said, "Hey, we watched your body cam videos. We don't think you got a voluntary consent. Yeah, here's 7 pieces of case law, fuckhead. Stop trying to back the 19-year-old dispatcher. Get a fucking life."
They dehumanized civilians.
You don't like treating turds, right? You're like, fuck them. The ambulance can take care of them, right? And I had a problem treating, gangbangers and the people that were the pieces of shit of society, right? I had a great mentor that told me, "Well, Sean, guess what? That's a live tissue lab, bro. Anytime you can come to one of these shitbags, absolutely do the best you can. Absolutely, because what if he gets hurt, right? Or she gets hurt, or he gets hurt, then I can perform that flawlessly because now I've had some reps in." Everybody get that? Everybody with me on that?
They made jokes about their genitalia and harassed members of the audience.
All right, so normally in my class, we open up that beer tap and I just start spraying people with information. But today, you guys are just gonna get the tip.
I would be remiss if I didn't remind you or let you know that I have a 3-inch dick.
I'm not the one with a 1-inch dick.
I watched this car come off the highway and I fucked the shit out of the female driver. She doesn't want to fuck me back though.
That's not an 18-year-old kid dressed like Jesus coming eastbound out of Trenton. It's a 75-year-old black man, a change in drive behavior, came into a gas station, and I'm like, what the fuck? And you know what? Shame on me, because I look in there and I'm like, oh, got a couple small rubber bands. And all I'm doing is asking, hey, what's up with that?
And believe it or not, according to CBS News, well, maybe not in New Jersey anymore, but in other states, apparently this training is continuing to happen.
Yes, this is why I switched to injection-free weight loss.
I was eating healthy, working out every
Street Cop's website is promoting upcoming training across the country. Benino did not respond to CBS News for an interview request. He did post a video in response to the comptroller report apologizing for the offensive language and denying that Street Cop ever taught unconstitutional policing.
In fact, right there on their website, they are advertising this year's 2024 Street Cop Training Conference in Kissimmee, Florida, April 28th of this year. So just here in a few weeks. Look at this. Here's the cost. Per person, $699. Why so much? Well, I'm sure it has nothing to do with the fact that taxpayer money is likely paying for this. As far as the guy saying that he hasn't taught anything unconstitutional, well, I will link below and put on the blog the actual report from the comptroller's office in New Jersey that goes into great detail, not only on what I've told you about here, but many more things that they've said that were blatantly wrong and unconstitutional. It's all laid out there with the case law. It's a fascinating report, and you can go over it as much as you want. All they're going to do is just hide next time. They're going to make sure there's no video. They're going to suppress the course materials. But this, I predict, is going to be a treasure trove of future civil rights litigation, both in criminal cases and in civil Section 1983 cases. We need to know which police officers have been to these seminars. Who taught there? Is there video? What was said? What were the course materials? This is going to be more important now than ever. If you have any additional footage from any of these seminars or know anything else about these instructors, now is the time to start compiling it and spread this footage. Everybody needs to know. The taxpayers need to know, not just in New Jersey, but elsewhere, because look at all the states that have paid taxpayer funds to pay for these courses. The taxpayers need to know that they're paying for these cops to go and denigrate them, to laugh at them, and to celebrate and teach each other how to violate your constitutional rights. So as always, thanks for watching. Please subscribe both here and at the blog at thecivilrightslawyer.com. If you have a video you want to submit, please use the submission link below. Follow me on Twitter at JohnBryanESQ or on Facebook at the John H. Bryan.
All right, so if permission, the shameless plug, because I know it's past the time, right? Malika, is it fine? Shameless plug?
Yeah, go ahead.
All right, so it already kicked off at it was 10 minutes ago, I'm guessing it's saying, right? You guys, because I know we've been in here in class, but there's a new video up, right, for
Ready to straight.
Starting a civil lawsuit. For this one, I used Georgia because there was an extensive study done with Malika Trading Brigade and myself, mainly when we were looking at some things when we were doing the Torts for All. And make sure you guys go and subscribe to the Lawful Living 007 YouTube channel as well as Off Duty Alibi, and go and check that out. It was 33 minutes ago, obviously, when it started, but we were here, right? Normally, for every premiere, I'm there looking at it, but since we're all here, it is what it is. But I'm going to put that in the chat and just go and look at that video. It's just 7 minutes. I don't think you'll be disappointed, and I trust it's very helpful to what we do here at Lawful Living. All right.
But before we go on, I just want to talk a second about what we just saw, because I
right
could
ahead.
tell in the comments that everybody is probably where I was when you showed us first on the amicus.
Pissed.
I was yelling.
That shit crazy.
I was yelling on the call.
Yeah.
I was saying all types of. I recommend highly that everybody on here consider doing a records request for all of the agents that attended these conferences, guys. All the agents that attended, when they attended, how many times? Is it yearly? Is it every 2 years? Is it every 3 years? Is it every 5 years? Who went? And the reason we should be able to get that information is because it was paid by the public monies. They didn't pay separately out of their paycheck that they received, which is still public money. They didn't privately choose to go to this. They were sent. Does everybody realize the problem?
Yep.
And Post will also give them credits for going to this class on their certificate. They'll get credits for it.
Do y'all hear this? They are
Mhm.
encouraged.
To violate their duty.
And they're being sold that it is compliant to the Constitution. That is what it says on their website.
Hey,
And so, of
Malika,
course, these agents are going to argue just like the attorneys argue. It's a democratic republic. No, it's not.
Hey, Malika,
The word democracy does not show up anytime at all. 0 times.
can somebody go to the? I would like to just show this. Is if you go to the Prescott Police Department website, if someone can pull it up, I
Prescott?
can't do it.
Prescott, Arizona.
Prescott,
I also
there.
want to let you guys know that we have a spy in their community that's subscribed to get into their private forum. And we can actually see the shit they talk about.
Correct.
We're being given screenshots. We scroll live.
I got all their PDFs.
We download their PDFs. We are downloading their PDFs, guys.
Can someone go to the Prescott Police Department website? You got to see this.
I just want everybody to know their street cop website has been infiltrated. One of our friends is on there, giving us all the goods we need. This is why when people just see the brutality and they just tag us in it, they just tag us, Malika, help. It's like, we cannot help everyone, but we can show people how to help themselves, and we can show people who want to help others how to help others, because it takes skill in learning, teaching, and coaching if you want to help other people.
Can you scroll down on that? Oh, check this out. Look at this. Look at the pictures. Values. They're pointing a freaking rifle right at you. Great values.
As I've heard, you guys have heard me say before, I don't have any problem with their actual terrorist organization. If somebody signs up to be a government agent and they want to be terrorized by a terrorist organization, and they agree and they apply and they get accepted and all of that shit, I think they can just go fuck themselves.
But every
My
single
problem is when they try to do that shit to people who have not subscribed under the guise that it doesn't matter if we subscribe, you're going to get these benefits. That's where I draw the line.
Yeah. It's just crazy how everything is intimidating on their website. But it also says right there, to protect the rights of all people. Right there.
I'm protecting the shit out of you when I bust open your window and drag you out and cut you up with the shards, because you didn't obey my authority to invade your privacy and do a unlawful taking.
They're blocking the road with their bikes. How awesome is that?
Well, I'm looking for criminals, and you seem like one questioning my authority.
That is militarization.
Look at all the guns on the motorcycles right there. Look at
very democratic. Look at them coming out the military vehicle, looking like they in Baghdad or something.
Yeah, right.
Crime prevention. No, bitch, you do not get to do that.
What they're doing is called drug interdiction. So if you're just traveling and you're trying to get from point A to point B, and you happen to travel down a through a neighborhood that's considered quote unquote high drug activity area, and they're policing that area, they will pull you over and do a drug interdiction. What kind of stop it's called?
You gonna get this diction I'm about to put on you, this jurisdiction.
Look, citizen, I'm disgusted with you. You're lying to me. Look, he just got a disgusted look on his face. Look at that guy.
They call it a contextual stop. I think that's what they call it.
That sounds all like administrative larceny to me.
Correct.
And I'm not saying they can't do it to someone. I just need to see the record that reflected that you could have done it to me at that time.
Don't look like that guy is serving and protecting there. Looks like he's questioning and just doesn't look like he's on the people's side.
Looks like he's look at
Interrogating.
disgusting.
Yeah.
Interrogating.
Again, I'm not
It's like
saying you're not
martial
supposed
law.
to interrogate. I'm not saying you can't bust out somebody's window and drag them out and cut them up with the shards. I'm trying to figure out why you, not why, okay, but the evidence that supports that you could have done it to me at that time. This is what nobody talks
Exactly.
about.
Yes.
Keep scrolling.
We
You're
are
gonna
so
love
busy
it.
trying to show that they shouldn't be doing it at all. And that's why I'm trying to give you guys
No.
the correct perspective. Maybe there is somebody who they could just kick their ass just by looking at them and saying, I'm disgusted with your stupid face. I'm just trying to figure out what is the documentary evidence that it was me at this time. And we have to keep the argument narrow to that, or we
Exactly.
will lose. We will give them an out and they will take it. Only we can prevent these forest fires. When do it to your public capacity. Yeah, I mean, whoever agreed, right? Exactly. Do it to your agents and agency that agreed that that's how y'all gonna get down. I'm not, if y'all like it rough, I'm not here to take it from you. That's between you and the other adults that agreed to be in that type of relationship with you.
Another thing that they're doing too is being cross jurisdictionally certified or something where they'll abrogate their duties. I think that's the right term, right? By having some type of federal type of like federal marshaling type of certification, and that's used to evade a Bivens case.
We ain't gonna let them out this lock we about to put them in. This headlock we about to put them in, they not gonna wiggle their ass out.
For real. Not at all. Not one bit. Okay. I yield. Thank you
Gratitude.
guys. Appreciate you all. And please go and look at that 7-minute video at the off-duty alibi on how to start a civil lawsuit. Even though it says Georgia, you will, and I encourage you to find parallels for the state near you. All right.
Everybody needs to get with Hassan and get with the jurisprudence gym. It's like the best thing.
Oh wow, bro. Okay, I
See,
did
it's not just
know.
me now. Get with Hassan, pay him whatever he asks. I mean, y'all could think we bullshitting if you want. It's whatever. But I use the bot that he programmed, and I use it to help everybody that approaches me for help. So if you guys want to get stronger in assisting yourself and taking advantage of Hassan while he is available and willing, because we don't know what's going to happen in 2026. So Hassan might get famous and blast off into the astral planes.
Jesus Christ.
But
No,
while he's
I'll still
here,
be here. I'll still be here. I'll
And guys,
still
it's
be
next
here.
level. It's the next level. Get it? Don't fuck around. Get it.
Thank you so much, Eldon, because I gotta
okay,
admit,
I'm
I
going to
know
stop my commercials. I think Eldon's is better.
I'll admit I wanted to make sure that when Eldon got his Arizona remedy, I wanted like, bro, it's not just this one thing. Look, I'm gonna give you this and this and this, and I wanted to make sure, like, bro, were you satisfied with your session? I always ask everybody for the record when I record your sessions, are you satisfied? You know what I mean? Because we want to make sure that your feet are on the ground and the gloves are tightly wrapped around your wrists and on your fists so that you can punch the fuck out of the noses of these attorneys and start collecting attorneys' tears.
Absolute
You still have to have the real eye, and you still need as above, so below. Period.
Word. Just email me if you guys, because I'm here on my phone.
Oh, and since it is Tuesday, go ahead one more time, someone, and post the Newbie Tuesday guide.
Word.
post it one more time so those who may have joined us after we had gotten deep into our discussion, we may have forgotten to post it on a regular basis. So post it, the newbie guide, share it, guys, use it. Watch for it to be updated too.
Indeed.
All
I know
right, guys.
Linnell was sharing it quite a few times, but you guys
Yes,
got
I
it.
just wanted to make sure that everybody got it. So y'all can email Hassan directly. He has offdutyalibi@gmail.com right here in the chat. Off duty alibi, just like it sounds, at
Word.
Gmail. All right, guys. Peace.
Gratitude, sis. Peace.
Yes.
Y'all.